Judges.
Yeah.
Witness. Interpreter.
Magistrates.
Discharging a firearm in a built-up area, reckless endangerment of people or property, a failure to take reasonable precautions to avoid danger, and providing a firearm or ammunition to a person not allowed to possess it. I beg your pardon. That last charge was against Adrian Snyman, who gave the weapon, if you like, to Julius Malema. He has since been acquitted, though, which is why we're only anticipating that Julius Malema will be in court today. Let's take you back to KuGompo City. Once again, link up with our team, including Sakina Kamwendo and Samkele Maseko. Sakina, I'm hoping you're able to hear me above the noise pollution, as you put it earlier today. Those EFF supporters, many of them also attending a night vigil yesterday, but you can see still very much in high spirits.
Position. And thank you so much, Ayanda. And just picking up, because the reality is we can't hear ourselves think right now, Samkele Maseko. But of course, we are now counting down. And it's going to be a marathon this morning, because we are going to hear from the magistrate presiding over this case, Magistrate Toinette Willefeer. She will be first after the NPA. Of course, the state will present its case in terms of just aggravating circumstances. And listening to the NPA spokesperson, he was quite intent on making the point that there was no remorse from Mr. Malema's side as a lawmaker, and which is why they actually view this in part in a very dim light. And of course, after hearing that, we know that the magistrate will then go. She will further apply her mind. We are expecting her to hand down, of course, her sentencing judgment tomorrow.
Indeed, we are expecting her to hand down sentencing judgment tomorrow, particularly noting that the NPA has been monitoring Mr. Malema's public utterances. They've been monitoring him in and outside this court, addressing his members and supporters, riling them up, particularly against the judge, and riling them up on this particular case, and saying that it was a toy gun that he ultimately used, repeating his legal arguments in court and outside of court, particularly on those direct attacks on the NPA, on the judge, on the magistrate. Those may some of the issues that may have aggravated the NPA to go for the harshest punitive measure, particularly at a time where South Africans are saying it seemingly looks like politicians are above the law. It's a select few, it's Animal Farm, where some are found guilty and others are let go because of their proximity to those in power, whether economically or politically.
And it's going to be interesting, because in terms of case law, obviously I'm curious to hear what the judge or the magistrate will have to say in that regard. But it's not looking at this point as if Mr. Malema is going to get off with a light sentence. By all indications, from everything that I'm hearing out here, it's pointing to a custodial sentence.
It is pointing there, because even with him, he's been ultimately saying that he expects the state to get that 15 years direct imprisonment, and which for him is an issue that signals political persecution against him. But also, you've got to look at it in this particular aspect, Sakina. You've had that mayor in the Eastern Cape, Kumkiti, of her son,
yes,
who shot up a gun. What is happening on that particular case?
And that's not the only one. There have been several.
You go to political funerals, there are guns that are shot up in the air at these political funerals where political leaders are present. And that just may also be one of the aggravating circumstances that the state is saying we've got to clamp down on a political leader in order to get the message down to those who may be branding these guns at funerals, who may be branding these AK-47s, these 9mm guns in the air after funerals, particularly in volatile provinces such as Gauteng, where you've got a lot of political killings nowadays, in KwaZulu-Natal, where the political killings task team was inceptualized to go and work, and of late in Limpopo as well, where you've got councillors whom are brutally being gunned down, and just the branding of guns within this country, within the political space, is seemingly out of control.
And that, of course, is the crux of the matter. That is why we are here today. Julius Malema, of course, being found guilty in October last year. And this is a case that, of course, has been going for the longest time. And here comes Mr. Malema. Mr. Malema making his way through. And we've got Gabi there on our camera. He's going to capture these visuals for you. He is arriving as we speak now. This is Julius Malema arriving at the KuGompo Magistrates Court as we try and just make our way closer and hopefully be able to just sneak through here. It is a scrum, I must tell you, and it's all about holding your balance and making sure that you can get as close as possible. And this is, of course, where Mr. Malema is arriving, right in front of us here. Just one question here as Mr. Malema gets out. Mr. Malema, good morning. Mr. Malema.
Okay.
Good morning, Mr. Malema. How are you feeling this morning? Mr. Malema. He's obviously not going to speak to us. Mr. Snyman, good morning to you. Mr. Snyman. Mr. Snyman. Watch here. Mr. Snyman, they're not talking to us, Sam.
They're not talking to us.
They're not even looking at us.
Nobody's at this point in time. They will remember when they come out of, oh, there's Sakina.
When
Hello,
there's something
Sakina.
to say, exactly. But of course, you would imagine that they were told. They also under strict instruction from their legal teams not to speak, not to say anything in case you just make things worse at this point.
They are definitely under strict instructions from their attorneys to say little, keep quiet until this court is done, as you can see. And here these loud cheers for the Commander-in-Chief of the Economic Freedom Fighters as he goes towards this mitigation of his sentencing for the next 2 days.
Yeah, and we heard, of course, Malema's legal team the last time bringing out, amongst others, as a key witness, a social worker who spoke to his character, who spoke to the fact that he's a family man. Just watch your step there, Sam, so you don't fall on camera here, Gabi. And of course, you know, it spoke to the things that he's done in his community. But as I was saying earlier, you heard, for example, Magistrate Toinette Olivier, when she was speaking about things like, for example, the soup kitchen. She didn't think too much. People trying to make their way into the court, and there's no space there. There's no space.
It's a very small court. It's a very small court. And even last time, there was this particular same issue where the Secretary General of the EFF and also Dr. Mkhinim Chwako had to go and quell tensions of some of the members of the EFF and with the South African Police Service that is ultimately protecting public order policing, that is protecting this particular precinct and EFF members from not being unruly and not destroying any public property. It's going to be a very important case, particularly on that issue of community service. The soup kitchen he runs in Limpopo, in Sishiko, where he feeds thousands of unemployed, destitute South Africans whom need a meal that he can ultimately assist, and those families that he has helped to build and put a shelter over their heads. Those are some of the issues that will definitely try and help him to mitigate that custodial sentence of 15 years. That's going to be a very important aspect of that soup kitchen. We've also seen him populate that particular work on his social media account, on his X account. Cheeky Malema, he'd always bash the lawyers, bash the judges, bash the magistrates, but on the side, just populate that particular work that is needed in his court case to try and reduce that particular sentence in order to be able to fight for it and have a prospective opportunity of a win at a higher court.
And of course, we did see him beef up his legal team, bring in, you know, the country's best, if you will, legal minds in order to basically issue that appeal here at the KuGompo court once the sentencing is done here. Because to be fair, for all intents and purposes, he's accepted that he will get the maximum sentence. They are simply waiting, it would seem, for their chance to lodge an appeal.
The truth of the matter is, Sakina, if we are to be fair, if you were to look at this particular case, he underestimated it. Malema underestimated this case, and at the last hour, when you could see that things are going south, he bolstered his legal team, but it was all a bit too late. And that is why, at the end, he brought in the big legal eagles, the best of the best when it comes to South Africa's defense. And this particular case, it will work for him going into the future, going into the higher courts, if we were to receive the harshest custodial sentence at this particular court, he will definitely have a particular attention to this case, which he may have underestimated, unlike other cases he has had to deal with before.
And of course, I can tell you, the NPA not relenting on this one. They are going for the jugular. They are going for the maximum sentence here. And that tomorrow, when we are here tomorrow, once that sentencing is being handed down, we could be talking about Julius Malema being sentenced to imprisonment, direct imprisonment, because that is what it is looking like right now. All the people that I've spoken to who may have some sort of insight into this matter are leaning towards that sort of direction. And of course, we will wait because it's today and of course tomorrow. So we will continue hearing arguments today. And basically, the NPA has indicated that they will be, of course, putting their case forward in terms of aggravation of circumstances for the sentencing. And then, of course, by tomorrow, the judge, or should I say the magistrate, Juanette Willefeer, she will hand down her verdict in terms of the sentencing of Julius Malema, who was found guilty in October last year. And this, of course, is the scenes currently here from the KuGompo Magistrates Court. And as you can see there at the entrance, we did indicate to you earlier, heavy police presence, a huge deployment of South African police services, and to try and keep these people, as you can see, so many people trying to get into the court. But I can tell you that the court is full, even in terms of the media and who's been allowed in. There is limited space, and there you have the announcement where people are being told to please try and make their way away from this entrance because there is no more space in the court. It is full, and this is where we are at now. So proceedings will now shift from outside to the inside of the East London or KuGompo Magistrates Court, and this is of course where we will continue to hear what will be said by the state in order to try and achieve that maximum sentence that they want for Julius Malema in terms of the charges, which they view in a very serious light, and they of course will be making their case in terms of aggravation today. So for now, I think we're going to hand it back to you in studio as we catch our breath and try to position ourselves, vehicles still moving about, but of course the proceedings now move to the inside of the court. And I must say, one of the things that I hope will be checked and has been improved upon today will be the acoustics inside court, or at least, you know, that we can get a better sense of what is being said, because the last time at points it was really difficult to hear what was being said by those inside the court. So we're hoping that some of those issues would have been taken care of as well. But this is where we are at, and this is of course where we're going to leave it for now, handing it back to studio as proceedings move from the outside to the inside of the Magistrates Court here in KuGompo City.
Sakina, you most certainly do deserve to take a breath. That's SABC News anchor Sakina Kamwendo, as well as reporter Samkele Maseko outside the Magistrate Court in KuGompo City in the Eastern Cape. Of course, you would have seen in just those visuals a moment ago, EFF leader Julius Malema making his way inside the courthouse, flanked by security personnel, but also leaders of the economic freedom fighters. One I could spot there was Secretary General of the party, Marshall Dlamini, who has, among others, been interacting or almost engaging the supporters on the ground. As was indicated and been the word, is that EFF supporters today were probably given strict instruction not to engage the media. As you can see, those are live visuals now from inside court. Sakina, reminding us of the acoustics at the last appearance here where this matter began. Now, the issue had been around the sound, but of course today hopeful that most certainly the legal proceedings will be quite audible for all of those inside the court. But just to remind you of what brings us to this courthouse, 2 days for arguments for pre-sentencing that will take place. Now, it all emanates from the guilty verdict. EFF leader Julius Malema, who was at the time accused of firing shots from an assault rifle. This was, of course, during the 5th birthday celebrations at the Sisa Dukashe Stadium in Mdantsane in the Eastern Cape. Now, this was in 2018. His defense had claimed that Malema had used a toy gun to excite people, and that was the weapon that was loaded with blanks. Of course, we know that Judge Toinette Olefir was somebody who was not convinced by that defense, and he was found guilty on the charge. And just to take you through the charges, in fact, it is unlawful possession of ammunition, discharging a firearm in a built area, and reckless endangerment, also unlawful possession of a firearm. The co-accused in this matter at the time was his bodyguard. You would have heard a bit earlier on Sakina trying to also get the attention of Mr. Snyman. That's his bodyguard, Adrian Snyman, who was charged with supplying the weapon but was found not guilty, which Malema and the party members had all criticized. I remember Naledi Chira was among those EFF leaders who went on to indicate that if you've gone on to acquit the person who was accused of supplying the weapon, then what are you charging the person who allegedly was in possession of the weapon of? So most certainly it was quite the talking point among legal analysts, a number of people saying that if you cannot speak of the whereabouts of specifically that firearm or the person who owns the firearm, if they've been acquitted of all proceedings, then it most certainly leaves a lot. But they did get to the guilty verdict, and here we are. Just to give you the natural sounds of what we're seeing there in court as we speak. We do apologize for a bit of those shaky visuals, but as you can see, everybody, journalists already, any moment now, we will see the judge enter the courthouse. But again, to take you back to some of the legal analysis, or at least what could be seen as the minimum sentence. The minimum sentence for the specific guilty verdict, it stands at 15 years imprisonment. So he faces a potential, though not mandatory, 15 years imprisonment. 2 days of pre-sentencing hearing that take place now. And the EFF, of course, has indicated on numerous occasions when the opportunity arose to indicate that they will be appealing the conviction itself. And as much as they continue with the proceedings now for sentencing, they have indicated that, of course, they will appeal the conviction itself. And among some of the statements, again, it seems it would be centered, when it comes to appeal, it would be centered around the acquittal of the bodyguard. That how do you continue if you're going to acquit the bodyguard of having handed over a firearm, and then somebody else is then convicted for possessing that firearm, in as much as they've gone on to state that what they fired was a toy gun. But what we're expecting today in mitigation of sentencing, or if you will, the sentencing head of arguments, is there legal representation to speak about the character of EFF leader Julius Malema. At the start of the proceedings, we had heard last time that he was a man who had many charitable activities. He was a giver over the years. We've known that as an EFF leader, he has, among others, built a church where his mother and grandmother used to congregate. He built the church from scratch. He is somebody that has a soup kitchen. On many occasions, he would be an individual that would help even the young that are in school. This, you can see there visuals of EFF leader Julius Malema. By his side, Secretary General Marshall Dlamini, and as you can also see the Deputy President of the political party, Godrich Gati. All EFF leaders, one assumes, would be present in Mdantsane today in the Eastern Cape, of course, at KuGompo City for those proceedings. It's been a long particular case, this one. It's starting off in 2018 until now, 2026, something that even others had felt was quite concerning, that the matter had been running since 2018 until 2026. Legal experts had come out to indicate that at times when you find a legal matter running for this long, it would have been perhaps trying to align the diaries of legal practitioners, but also you can find somebody who wants to exercise their right to a full and fair trial by ensuring that experts are brought in, be it ballistic experts or whatever it may be. In this instance, so it could be one of two reasons, be it that the need to align diaries of all legal practitioners that would be before this court, or at times it's an accused seeking to exercise their right to properly defend themselves by ensuring that as many witnesses, including experts, are brought before the courthouse and to assist in his defense. As you can see there, Senior Counsel Tembeka Nqubay-Tobi, who's among those who have been brought into this case, of course, was not there from the onset, but has been brought in to bolster the legal team. We heard him at the last appearance being among those who spoke and spoke of the character of Malema, because in this part of the proceedings, it would be quite important to speak of the character and what becomes the loss in society if you were to imprison such an individual, a leader of a political party, but also whether it does serve the purpose if you incarcerate as opposed to any other type of corrective action. As you can see there, a moment with his legal representative, one can only assume what would become the last conversations now at the start of the hearings today. 2 days it will be of pre-sentencing hearing. A very pivotal moment for the economic freedom fighters, and as much as we're seeing somewhat of a cool, calm and collected individual, if we were to go by just one's body and just look at the body language there, but most certainly a big moment. You can see the numbers gathered outside a bit earlier on that it is a significant moment because it is sentencing. A guilty verdict was handed down last year, and now would be the final moment where the courts decide that what becomes a suitable sentence in this regard. Should he be incarcerated? Live visuals you can see there from outside court, a number of EFF supporters coming out to support their leader in his hour of need, if you will. Now again, it becomes the question that many legal analysts are asking: what becomes a suitable sentence for an individual, a leader who would have discharged a firearm in public in 2018 at a stadium? Of course, again, the defense maintaining that it was a toy gun that would have been discharged that day, and of course with blanks. It seems everybody is now rising in court. We assume that the magistrate, Toinette Olafir, is making her way inside. Let's listen into those proceedings.
Just please leave space to write, ne? For me to. That's all I wrote less. Maybe go on video. Thank you. We are on.
Thank you very much, Your Worship. The State versus Julius Malema, Julius Sellers Malema. Selo Malema, the case number is Regional Court 44620B. The date is the 15th of April 2026. Presiding officer, Mrs. T. Olafir. Public prosecutor, Advocate J. Caesar. Defense, Advocate L. Hodes, SC. And Advocate T. Nukai Tobi, SC. The interpreters, Mr. Kumkwensha. The clerk is Ms. Mkameni. Your Worship, this matter is set down today for sentencing proceedings. I confirm that the state, both the state and the counsel for accused number 1 have handed in their heads of argument already. If the court can just confirm whether the court did receive. Same.
Thank you. Just a minute. I'll acknowledge everyone. Thank you, Advocate Hodes. Good morning.
So I confirm the appearances on behalf of the accused, so only one accused at this stage. And we're joined, Your Worship, by Peter Musala from the Cape Town Bar, who's also part of the team but didn't have an opportunity to introduce him to you this morning, Your Worship, for which we apologize.
I saw there, I thought there's an extra manpower. Oh, that's fine. Okay. Thank you. So for now, is it only yourself I'm acknowledging or whole defense team?
We will be here for a long, long time to acknowledge everybody.
Okay, I know Advocate Otis, Advocate Nkukai Toby, Mr. Levitt, Mr. Mkwanazi, the Mvumbi.
Your Worship.
Mvumbi. Zilba. Mr. Marshall, thank you. And then Advocate Cesar, all acknowledged. Thank you. First aspect, I do confirm I received the written heads of submission by the defense. I am in receipt of the pre-sentence report submitted by yourself on the 23rd of January 2026 by Ms. Thompson. I received the state's heads of argument and subsequent supplementary heads of argument. And then just before we start, to inquire regarding the media who's present, and then just briefly acknowledge if this is per the list, because after this list there are not going to be any further media allowed because it's full. State and defense in agreement with that, unless some vacate and others enter. Okay, so Kumkani FM. Okay. The Voice Lounge Radio. EFF Communications. Okay, you're present, okay. News 24. Okay, not. All right, thank you. Then SABC News.
Present.
Izolezwe. Daily Dispatch. Umpuma Kapa TV. Reuters Africa. Okay. Thomson Reuters. Then Eyewitness News.
Present.
Marula Media.
Present, Your Worship.
Ikamaku News.
Present, Your Worship.
Informal Digital TV.
Present.
Stepla News.
Present.
AFP.
Present.
Angola FM.
Present, Your Worship.
Anyone present who's not been acknowledged? Sure. No, guys. Where's your documentation? Okay, just please, just one at a time, briefly, in 2 seconds, announce your station, please.
Newsroom Africa.
One at a time, please.
Newsroom Africa.
Newsroom Africa. Acknowledged, yes.
MDN. Sorry.
You are very eager. Let me hear you first. Okay, you are?
MDN TV.
MD.
NTV.
MDNTV, yes.
Daily Maverick.
Daily Maverick. Yes. Okay. Is that News 24?
No, that's
Different. Okay. Netwerk 24, yes.
Cubit Media.
Cupid.
Cubit. Q-U-B-I-T.
QU.
Media.
Cubid Media, yes.
Shallow images.
Gallo.
Shallow, yes.
Yes. Mail and Guardian.
Yes,
Oh. Yes. Everyone. Okay, that's it then. Thank you. All right. Advocate affidavits. I do have a copy printed out of your head, so if you are ready to proceed, I'm ready.
Your Worship, I don't intend to be very long because the heads were filed. But I'll
Yes.
start off with an apology, Your Worship, and I'll lead up to it. There's an additional case that I've given a copy to my learned friend, and I'm going to hand a copy to Your Worship, and I'll deal with it in due course of the Eastern Cape Division that's relevant of Mdantsane, and I'll explain. Your Worship, it was meant to have been included in our heads, but I was out of town and the incorrect copy was filed.
No.
But
Advocate,
I've
Liz,
made a
I
copy.
just want to make sure, is there a microphone in front of you? If you can just,
20, Your Worship.
no, oh, if you can just, okay. Thank you.
So, Your Worship, in summary,
I just want to establish one aspect. Although we filed the heads, are you not of the view that at least our record should reflect what is contained? Because if we get to transcription, this is obviously not going to form part of the formal record. So if it takes time, it's fine, but it won't be on the record if it's not.
Your Worship, it was my intention to deal with the heads of myself and my learned friend. It would make no sense for me to stand here, read my heads, and he reads his heads. So I'm going to anticipate his heads and give him a chance to then deal with my submissions in relation
Oh,
to his
okay.
heads.
I know,
So I
follow
will
you.
take the court through. In fact, Your Worship, my intention is to go as to what happened on the last occasion and what the arrangements were, what's then transpired, followed by the heads, a few submissions, and the conclusion. So I won't be long at all, Your Worship. I do believe that we can even finish this morning on the submissions and all we need.
Not a problem. Thank you.
Your Worship, Your Worship will by now have a copy of the transcript of the previous occasion. So just to put everything into context, Ms. Thompson testified on the 23rd of January 2026. Whereafter this matter was postponed to today, Your Worship, and possibly for tomorrow. And what happened in that regard, Your Worship, it's quite clear, is that I asked the court to inquire from the state, this is at page 172, whether they had in fact closed their case, and they said the state has not formally closed their case and we were waiting to hear. Whereafter they formally closed their case, Your Worship, and said that they're not calling any evidence in aggravation of sentence. That's from page 172 onwards. What then happened, Your Worship, was there was an agreement that we would file our heads of argument by the end of March, being the 31st of March, which would give Your Worship 2 weeks to go through the heads of argument and be ready for today. And we now know that we filed on the 31st of March, Your Worship, but absent this case that I had intended to include in the heads of argument. Whereafter the state only filed on the 1st of April, and I was told that they wanted to see our heads before. Whereafter, Your Worship, the state filed supplementary heads last week Thursday, on the 9th of April 2026 at 11:17, 4 court days ago. And they never asked for condemnation or even requested permission to do so, provided any explanation. Whereafter, Your Worship asked if anybody on email, if anybody was filing anything else, and it hadn't come to my attention, Your Worship, that we had not yet referred to this decision that I've now handed to my learned friend and to Your Worship of this division. So that would set the factual background to where we are at this stage, Your Worship. Now, turning to the heads, Your Worship, if I may take Your Worship through our heads just by way of introduction, and I don't intend to stand before Your Worship and read everything out. But what we did, Your Worship, and my learned friend adopted a similar approach in his introduction, is we described by way of introduction the offences of which the accused has been found guilty. There are 5, Your Worship, they may be summarised as being unlawful possession of a firearm, unlawful possession of ammunition, the unlawful discharge of a firearm in a built-up area, and the unlawful failure to take reasonable precautions to avoid danger to a personal property, and finally, reckless endangerment to a personal property. So those were the 5 charges, Your Worship, on which the accused was found guilty. And then what we highlighted and emphasised throughout the heads, Your Worship, is that all 5 charges related to a single incident being the 5th Economic Freedom Fighter celebration that occurred on 28 July 2018 at the Sisa Dukashe Stadium in Mdantsane within the jurisdiction of this Honourable Court. And what we say, Your Worship, and it's highlighted further throughout the heads of argument, is that all 5 charges were committed in a very short time span of less than 1 minute. And we then also, we had agreed on this previously, Your Worship, that there was no indication that any minimum sentence legislation applied in this case because the accused had not been warned accordingly. And I do believe that there's common cause on that, so there's no need to go into the cases dealing with that particular aspect. And then we went through the report of Ms. Jessie Thompson, Your Worship, who was called to give evidence in mitigation of sentence. And she highlighted the accused's personal circumstances, and more particularly that he was a 45-year-old first offender, having never been convicted of any offence. And we say equally significant is the objective fact that despite the lapse of 8 years since the commission of these offences, the accused has not been convicted of any other offences. So he's 45 at the moment, he was 37 at the time of the commission of the offences, and he led a blameless life in the interim. There being no intervening incidents or anything that would aggravate the circumstances of this Honourable Court. We then summarised Ms. Thompson's report, Your Worship, and who she had interviewed and what information she had utilised, and that she sought to follow the Zin triad and all the relevant considerations. And she had regard to his personal circumstances. And we say even that in relation, this in paragraph 13 of the head, Your Worship, to the principle of remorse, she found that the accused continues to assert his innocence. Nevertheless, she was of the view that the accused regrets the incident and the consequent result that people may perceive it as encouragement to handle firearms recklessly, which was not his intent. In that regard, Your Worship will know, and we received, as I recorded, Your Worship, the transcript, and Your Worship covered this also in questions of clarification and made it clear, Your Worship, on the record, and I can give the reference to Your Worship, that people are entitled to plead not guilty. That is their right, Your Worship. I put that to Ms. Thompson as a clarifying question, and she had agreed in that regard, Your Worship, that would be the case, that one may be entitled to plead not guilty. That's at page 162 of the record where Your Worship clarifies that. So that aspect was fully dealt with and canvassed by Ms. Thompson, and she said that she was of the view that the accused regrets the incident and the consequent result that people may perceive it as encouragement to handle firearms recklessly, which was not his intent. We then explained how she detailed the criminal behaviour and current offences, and that there were no cases pending against him, and she had regard to the prevailing circumstances at the time of the commission of the current offences and their seriousness. And in paragraph 15, we say in regard to the seriousness of the offences, she has submitted that it was necessary to evaluate both the level of actual and potential harm caused by the acts in question, as well as the degree of culpability attributable to the offender. And then in 16, we set out, Your Worship, what she highlighted, and that was that he had obtained the firearm from an individual most likely affiliated with tactical security services, possess and manage a licensed firearm. He had done so solely for the purpose of discharging celebratory shots at the event. He had not acquired the firearm illegally for a prolonged period or within any intent to facilitate further criminal activity. He returned the firearm to its lawful custodian promptly after firing the celebratory shots, and he possessed the firearm and ammunition only for the period during which the celebratory shots had been fired, which, while not precisely timed, he estimated to have lasted less than 1 minute. So he highlighted those aspects which she had brought to the court, which the court was aware of. And we also say that she highlighted the purpose and the constitutional rights to life and bodily integrity, that is the purpose of the Firearms Control Act 60 of 2000. And in that regard, she said as follows, and it's in 17.1, there is no evidence that the accused intended to cause harm. Secondly, that by neglecting to take such precautions, it has been said that the accused acted recklessly. thirdly, that the discharge of firearms in a public setting conveys an inappropriate message, particularly from a prominent leader, but that it was noted that the accused regrets the incident, and that you said there was no evidence indicating any harm to a person or damage to any property. We say the firing of celebratory shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. However, available information did not suggest that the planning of this activity was undertaken with intention to commit an offence, endanger lives or cause damage to property. We also say, Your Worship, and I can give Your Worship the references in Ms. Thompson's report and in the record, that it's unusual, and this is illustrated, Your Worship, by the fact that the firearm in question was actually returned to Tactical Security Services before judgment was even delivered in this trial. Your Worship will find that at paragraph 50.4 of Ms. Thompson's report, and at page 35 of the record where she refers to it in her oral testimony, and that was never ever disputed. So we say that's a distinguishing feature, because all the cases that my learned friend refers to, and I'm jumping the gun to a certain extent, have firearms where the markings or distinctive features were obliterated, they were modified, and they were intended to commit more serious or heinous crimes, and therefore there was more to hand in relation to the firearms. The one possible exception, which I will deal with, is the Pistorius matter. It was a friend of his firearm that he wasn't licensed to possess it. The argument was the friend had handed it to him, saying there's one up in the chamber. In other words, it had been cocked. He denied that, but it was never put to those witnesses when they testified. Ms. Thompson also said this when she testified at page 35, that no individual was convicted of supplying or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. So that's a distinguishing feature that would bring us in line, Your Worship, with the Pistorius type of matter, and that we said that the court ought to have regard to. Now, I was at paragraph 20, Your Worship, that she said that she dealt with these individual objectives and had regard to numerous judgments, but could not trace any judgment dealing with accused persons who had been charged with discharging a firearm for celebratory purposes. Now, Your Worship will be aware now that's a big aspect that's covered to a large extent in our heads of argument, and that the state, in their heads of argument, say ought to be an aggravating factor. But I think they're missing the point, and let me make it clear, Your Worship. They say the fact that one cannot find any cases dealing with it doesn't have any significance. But the point is, Your Worship, if one has regard, and I'd even ask the court to take judicial cognizance of this, when we watch the funerals of prominent leaders and other people in the community, very often there's firearm shooting, but those people aren't charged. And there's no case that we were able as a team, a large team, to trace that would deal with such instances. And that's the point that we're trying to make, that it's very unlikely, and it hasn't happened in the past, that people were charged with those offences, even though we see them on TV on a regular basis. Then Ms. Thompson recommended, as do we, that all 5 charges arose from a single incident and the accused had not loaded the firearm. The charges should thus be considered collectively for sentencing purposes, and that was taken together. She then proposed a monetary fine, that the accused be restricted from obtaining a firearm license for a particular period, and a monetary donation. In the heads, Your Worship, at paragraph 22, we deal with her cross-examination, and that was put to her, and it's now on the strength of the listed decision we know from the judgment, that to impose a monetary fine would convey the message that the accused could pay his way out of jail. But her response to that was that jail is not necessarily the correct way to go. So what we say, Your Worship, is that even though the states take exception to the possible imposition of a monetary fine, we say that this is still constitutionally recognized as a possible offense and ought to be taken into account. Then she was re-examined, Your Worship, and then the court asked clarifying questions, and that's where your Worship asked for clarification, as I've dealt with, as to the plea of not guilty, which one is entitled to do, and to put the state to the proof and the lack of remorse, and that and Your Worship also clarified the substantial contribution made by the accused to the community with the soup kitchens, and that there are several other soup kitchens. But she had explained that he'd used his money to do it, and he'd given money on his previous birthday to the establishment of funds and charities, which is in her report. Then we say in paragraph 24 that Ms. Thompson was of the view that there was no risk of the accused recommitting such an offence again, based upon the passage of time since the commission of these offences, and in not having done so in the interim, which is something that I've already alluded to. We then, and I think it's important that I clarify this because there seems to be some confusion in the heads of the state in this regard. We referred to general principles of the Constitutional Court concerning sentencing. In particular, we dealt with State v. Makonyane when the death sentence was abolished, and we highlighted paragraph 222, which is something that the state and the supplementary heads also highlight at the very same point. And the point that I wish to highlight there, Your Worship, and I'm not going to quote it extensively, is that the state not only preaches respect for the law and that the killing must stop, but it demonstrates in the best way possible, by example, society's own regard for human life and dignity by refusing to destroy that of the criminals. So all our sentences are blended with a measure of mercy, going back to the Rabi decisions, etc., Your Worship. We then also, on this principle, referred to the Constitutional Court decision of EFF versus the Speaker, National Assembly. And we said, this is the quote from paragraph 235, and ironically, they also referred to this in their heads, Your Worship, in the middle of 235. It is after all the embodiment of the legendary Lady Justice, a dispenser of justice who is blind and deaf to images of any reports on the good reputation or notoriety or personalities before her, but never misses any legitimate and relevant legal or factual points for or against any litigant. And then this court is required to always display the critical boldness to go against overwhelmingly popular and forceful opinion. And then we also deal with the Constitutional Court decision, finally, Worship, of Senwedi. In paragraph 27, it's a 2022 decision. It says, our courts must defend and uphold the Constitution and the rights entrenched in it. One of the most important rights from a historical perspective is unquestionably the deprivation of an individual's liberty. The court said in Ferreira that conceptually, individual freedom is a core right in the panoply of human rights. The apartheid regime repulsively and capriciously deprived people of their freedom under illegitimate legislation that paid no respect to the rights to freedom and security of the person. We are therefore constrained to jealously guard the liberty of a person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. So those were the cases that we cited, Your Worship, on general principles relating to sentencing. We then turned our attention, Your Worship, in our heads to sentencing concerning firearms. And we had regard to the article that my learned friend had provided to us of Detroit, relating to a note on sentencing practices for the offence of the unlawful possession of semi-automatic firearms, and that's what they had utilized the support that there should be a period of incarceration. And we quote from the report, Your Worship, and we say, and I'm just quoting the second paragraph here, from the investigation it's evident that courts are more likely to impose the minimum sentence in cases where the accused is also convicted of other serious offences, such as murder and robbery. In such cases, little attention is given to the firearm-related offences, as the courts are more concerned with the cumulative effect of the sentences imposed on different counts. We also then refer to the decision of Asmal. It's on the next page. Also, we say, from the Supreme Court of Appeal's judgment in Asmal, it appears that the circumstances under which the unlawful possession occurred and the purpose for which the semi-automatic firearm was possessed will play a pivotal role in determining whether substantial and compelling circumstances justifying the imposition of a lesser sentence exists. There's a reference to Delport and the gradation, which is also referred to in their heads, and that there's a quote that the grading of the offence will typically be informed by the risk of harmfulness and the culpability of the offender. We then make the bold submission that I've already made to Your Worship, that the minimum sentence regime does not apply in this instance, so that's at paragraph 29. We also refer to State versus Madikani, which the State has referenced, and we quote from that decision that we say what is notable from these cases is that imprisonment is not always the norm. And then we say as follows, that, turning to paragraph 33 now, Your Worship, that the case law, we said, sub 1, the circumstances of the possession are a central factor. If the context of the possession is part of an overall commission of violent crimes, the court will generally incline towards a harsh sentence in keeping with the objects of the legislation. That's logical, Your Worship, and speaks for itself. If a firearm is used to commit a murder or to commit a robbery, it's far more serious than a firearm that isn't used to commit another serious offence, which is what we submit the case here. Secondly, the purpose behind the possession is also another factor that emerges from some of the cases. We say, while not decisive, it is a factor that a court may legitimately take into account. Indeed, there is a vast difference between an accused who has been asked to temporarily keep a firearm while the owner goes shopping and a person who places a firearm in the boot of his car intending to hide it from the police. Then thirdly, the duration of the possession is a relevant factor. If an accused has been in possession of a firearm for a lengthy period, they cannot be treated the same. For sentencing purposes, as someone with fleeting possession of a couple of seconds. Fourthly, harm is a critical consideration. The court should consider what the harm is. We accept that possession is in itself a harmful thing, but there are degrees of harm caused by possession, so the court would need to satisfy itself about the harm it seeks to punish. Possession in celebratory context for a few seconds should be considered differently. And that's our submission. And then from the cases, Your Worship will also note from whom and in what circumstances the accused received the firearm also play a part. We then quote the Delport decision about Bin's Ward about predation, which turned on the circumstances and relatively innocuous possession. And we then turn in paragraph 35, Your Worship, to cases on discharge of firearms. And we say that they also do not always attract incarceration, and that regard is had to the circumstances and the context of the discharge. We then referred to the decision of State versus Fulyun, which Your Worship will remember is the case where the person shot at a motor vehicle in a public area because he believed it was his wife's lover's vehicle. He pleaded guilty and he was convicted, given a fine. On appeal, even the monetary fine was reduced. Then the second decision that we quote there, Your Worship, which I've already referred to, is the Pistorius decision, where there was a shooting in a restaurant in Norris by the name of Tasha's. Under the table, there were over 200 people in a very confined room of a restaurant. Fortunately, there were no injuries, but there was damage to the floor. It was a Glock 27 pistol, and we said that's the most comparable to you because we believe the witness was given his firearm back after the incident, and that he was the lawful possessor who had handed it over to the shooter, but they told him not to shoot. And we explained that in paragraph 37, Your Worship, that there were 220 people in the restaurant, so it was full at the time, that the accused admitted that he had taken the firearm because he was planning to buy a similar model. His version was rejected, but in that instance, Your Worship, the accused was sentenced by Masipa J to 3 years imprisonment, wholly suspended, and jailed in respect of the conviction in count 3, which was the shooting and discharge of the firearm. I've taken into account that no one was hurt, though the offence is a serious one, especially in the setting of a restaurant. I do not believe that the degree of negligence in respect of this count, that is count 3, justifies a sentence of direct imprisonment. We then turned, Your Worship, and we went forward in time to 2021, 29th of April, the decision of Mdantsane and another versus the state, where 2 policemen who were intoxicated shot at somebody in a public area on a boat, and they were charged with attempted murder, and they were intoxicated, which should be an aggravating factor. They pleaded not guilty. Their versions were not accepted, and they received on appeal from a sentence of 7 years a monetary fine from Van der Schyff J of 12,000 rand and 2 years imprisonment that was wholly suspended. This was also referred to by Ms. Thompson, and we then highlighted the factors that we say bear highlighting in that case, that No wounds were inflicted when the appellants discharged their firearms. Here there were no wounds or damage. Their intoxication was regarded as an aggravating factor, as was the fact that they were members of the SAPS. They said there in paragraph 14, the same incident gave rise to conviction on all three charges. The appellant did not engage in one act and then proceeded to engage in further criminal conduct. And then his lordship said to effectively punish these as separate actions is in our view contrary to what is dictated by a common sense approach in view of the fundamental requirement of fairness and the misdirection. And there was regard also, Your Worship, as in this case, the appellant's perceived lack of remorse as an aggravating factor, and as regard had to the decision quoted by the state in their heads of argument of Hewitt, which says that it's not an aggravating factor but can be taken into account. We then looked at, we cited paragraph 18, Your Worship, where the following appears. The question is whether direct imprisonment is the only sentence that would, one, take account of the interest of the victim by acknowledging the harm done to him, two, inflict punishment on the offenders so that the scales of justice are balanced, retribution, three, cause the offenders to reconsider their way and not commit similar acts in future, in brackets, deterrence, cause other people in society from refraining to commit similar crimes because they witness the offender's punishment and fear suffering a similar fate, that's deterrence. And furtherly contribute to the improvement of the offender and thus assist both offenders and the society, and in bracket rehabilitation. But you'll see there the definition in 19, Your Worship, in the middle. It says this occurred in a moment of madness, which is what they referred to. And the defendants do not seem to grasp the seriousness of their conduct. There is no evidence of any premeditated actions. There's then a quote from State versus Rabi, 1975 decision, which says punishment should fit the criminal as well as the crime, be fair to society, be blended with a measure of mercy according to the circumstances. Then we have set out paragraph 20, and I'll just quote certain aspects of it. In the fourth line, the goal of rehabilitation is to address the underlying factors that led to criminal behavior and by so doing reducing the likelihood of reoffending. However, this objective is generally not met by imprisonment. On the contrary, evidence shows that prisons rarely rehabilitate individuals but tend to further criminalize individuals, leading to reoffending in a cycle of release and imprisonment, which does nothing to reduce overcrowding in prisons or build safer communities. We go further down in that quote, the community is protected when convicted persons are removed from society. However, protecting the community from an offender does not necessarily require imprisoning the offender, and this purpose may be fulfilled through the imposition of other sentencing orders. We are of the view that the facts of this case do not support the finding that the appellants are a danger to society, that calls for the protection of the community through their incarceration as a specific aim of the sentence. And then we quote two other paragraphs, but once again in paragraph 21, that was mainly an act of stupidity, and that the appellants acted in the spur of the moment while under the influence of alcohol. We then referred here to the decision of Bader versus S, which involved pointing of a firearm, assault with intent to do grievous bodily harm, reckless endangerment to personal property, pointing of a firearm, in which a fully suspended sentence was imposed. So we say, with respect, that possession doesn't necessarily carry in its own a jail sentence. Then there's the new decision, Your Worship, that unfortunately, and I apologize, had not been included in our heads of argument. I gave a copy to my learned friend this morning. It's the decision of the Eastern Cape divisions that will be binding upon this Honourable Court in Mdantsane. It was the Port St. John Circuit Court, the decision of Brooks of this division, where in summary, Your Worship, a security guard who was in his 60s and had battled to find employment, was now working as a security guard. He was alerted to two youngsters, or to a bunch of youngsters that it seemed had gone into a media room to try steal things, and he ran after them and he shot them with an illegal firearm, Your Worship. He killed the one and injured the other. They were 13 years old, and in that matter, the Honourable Mr. Justice Brooks imposed a non-custodial sentence, a fully suspended sentence. So we say that's a case, Your Worship, in this Honourable Division where there was not only harm to one 13-year-old victim, but the murder of the other 13-year-old victim, Your Worship, and that person was not sentenced to jail in this division. We highlight, Your Worship, and I know Your Worship hasn't seen this, but in paragraph 10, where Justice Brooke says, the offences of murder and attempted murder rank amongst the most serious of the common law offences. Indeed, there can be nothing more serious than the unlawful deprivation of another's constitutionally protected right to life, or an attempt at such deprivation. However, one must take care not to merely consider the category or the objective nature of the offence. What is required is a consideration of the offence that takes account of all the relevant facts that are peculiar to the incident that defines it. We also refer, Your Worship, with respect to paragraphs 22 and 26. I know Your Worship hasn't had an opportunity to see this, so let me read them, Your Worship. 22 says, the court holds the view that all the aspects referred to above constitute substantial and compelling circumstances that would justify the imposition of sentences less severe than the prescribed minimum. Given the irretrievable loss of life, count 1 in particular calls for a substantial period of direct imprisonment. However, the identification of this principle in objective isolation is not the end of the inquiry. Uniquely, the interests of society in the context of the rural community in which the death of the deceased do not necessarily require ongoing retribution for what has occurred, nor do they require that the community be protected from Mr. Mdantsane by his removal from their midst. He is not a person who has shown a predisposition towards criminality that requires him to be rehabilitated or reformed. He poses no danger to his community or to society at large. He has made the necessary overtures to make peace with those families whom he offended by his reckless action. Obviously, the pain felt by the family of the deceased in count 1 is real and ongoing. Perhaps this will only dissipate with the gradual passage of time. It is not something that can be eradicated by the ongoing incarceration of Mr. Mdantsane. In 26, the 3 offences arise from a single incident. It is appropriate that the sentences imposed in respect of each offence should run concurrently with the other sentences to be imposed. For the reasons set out above, the court is of the view that the sentences imposed upon Mr. Mdantsane should be wholly suspended for a period of 15 years on condition that he is not convicted of any offence involving violence committed during the period of suspension. Then we come to the conclusion, Your Worship, where we say, I beg your pardon, Your Worship, prior to that, we deal with general principles concerning sentence, Your Worship. Just the issue of S versus R and another proportionality is important. And we've got the Takatsa Mashego, that was acknowledged by Sadi Walla J. Finding an appropriate sentence is a challenge faced by criminal courts daily, and sentencing is not a perfect exercise. What complicates this even more is that there may be more than one appropriate sentence in a particular case. And then there's reference to a footnote, and that sentencing at the best of times is an imprecise and imperfect procedure. There will always be a substantial range of appropriate sentences. But what we say, Your Worship, in 45 is that we've illustrated that mere possession and discharge do not always mean that there must be incarceration. Each case must be evaluated on its facts. The facts of this case are indeed unique. And we say, firstly, possession cases are frequently either suspended sentences or fines. Secondly, discharge cases have also frequently attracted either suspended sentence or fines. And thirdly, principles of sentencing are always applicable. Sending a person to imprisonment merely because they possessed a firearm with discharge is contrary to the law. In our view, there's no obligation that the court has to imprison somebody for these offences. And then in the conclusion, Your Worship, we say that this was that we adopt a cumulative approach, and there are 5 charges, all happened in one single event which lasted no more than 2 minutes. To send any person to prison for the single event would be shockingly inappropriate, that it can be dismissed out of hand without more. We say the lawful and appropriate sentence to be imposed cannot include a custodial sentence. Only a non-custodial sentence would be compatible with the principles of sentencing in South Africa. A deviation from that approach would simply show the accused is being singled out for unduly harsh punishment. And we say that this submission is fortified by the objective fact that there were no injuries sustained by anybody and no damage to any property. It is also underscored by the fact that this is a single continuous event of no more than 2 minutes and caused no harm to anyone. No court can tolerate the imprisonment of anyone for this incident. In fact, nobody testified that they were in fear of the accused by virtue of the offences committed by him. And we also highlight, Your Worship, that no evidence was led in aggravation of sentence. Now, Your Worship, as previously alluded to, and this is where it becomes quite difficult, but I do respect what Your Worship said, that these factors ought to be placed on record, so that there's a record of everything that took place, because to just refer to heads, and when the public don't know what was referred to in the heads, would be unfair to the public. So we turn then, Your Worship, to the state's heads of argument. As I said, Your Worship, they highlight the charges by way of introduction, as did we, and they're of the view, Your Worship, contrary to what we say, that a custodial sentence is inevitable. And they say, and this is where they have a, with respect, self-defeating and mutually exclusive argument, where they say the accused's personal circumstances were just ordinary. In the very next sentence, they say he is a leader of a political party. So on the one hand, and this is the conundrum that Your Worship grappled with Ms. Thompson, is on the one hand you say because he's a leader, he must be treated differently. On the other hand you say don't treat him differently, treat him like anybody else. And that's the general vein throughout their heads of argument and their supplementary heads. And this is borne out to us in paragraph 8, where they say there was a huge outcry from civil society that she brought to book for his crimes. So you can't say you can't treat him differently, acknowledging that he's the leader of a political party, but don't take that into account, but at the same time society is paying for his imprisonment. They then refer to the listed decision, Your Worship, which I've already referred to, where we acknowledge that imprisonment is a form of punishment and that it's an institution of punishment, not cure. We say that it isn't consistent with the more enlightened approach to sentencing before our courts in the post-constitutional era. That was a 1993 decision, Your Worship. We then, they then deal with the probation officer, and they try to say, Your Worship, that she said there's no case where a person is convicted of possession and evaded jail, but that's not in the record, Your Worship. I know the question was asked, but she didn't answer it or make that concession. If I can turn to the record, Your Worship, to just show that it's not the case. I know this is in their supplementary heads as well. At page 96, my learned friend says to her, and he's going through a particular case, yes, there were two firearms. The one who was sentenced to 15 years, one of the firearms were reduced. The one that he actually found in the rubbish dump, so it was a spur-of-the-moment decision by him. He did not have it for a long period of time. Still, he got an 8 years direct imprisonment. In this case here, the accused also did not have the firearm for a long period of time, very brief. Does not change the fact that he was still sentenced to direct imprisonment. What do you have to say about that? And her response at page 97, Your Worship, what I hear is again different circumstances, although it was also not for a long period of time, it was. I would not know why the reason is why it was picked up in the spur of the moment time, but also here that it was not the only firearm that was possessed illegally, which makes it different. And the use, I'm not sure whether the other firearm was used, but in combination, it is always to look at it. The circumstances in total, what I hear what he said, but for me, the circumstances again are different. I'm not sure whether it was an illegal firearm, whether it was seized to the state, what happened to it, which may also make it different. And that's the very distinguishing feature here, Your Worship, because it seems from those judgments that my learned friend was referring to, that those were illegal firearms that had been adapted and were then seized by the state. Here, prior to even Your Worship's judgment, the firearm was returned to its lawful owner. Then my learned friend asks her further, when he's pushing this issue, did you come across any case where such as this, in the firearm-related case, possession of firearm, where an accused was not sentenced to direct imprisonment, actually got given a fine to pay for NGOs, and so on and so on. And she says, as I've not come across, Your Worship, to any case where a charge was laid and the firearm was used for celebratory shots. So she never ever said, yes, I know of such a case, or I don't know. She says, I cannot find a case that's on all fours with this, because this was celebratory. So then he tries harder, Your Worship, at the foot of 97. He says to her, Have you come across a case when an accused was convicted of being in possession of a firearm, whether it's for celebratory purposes, whether it's just social, whether whatever reason? Have you ever come across the case when an accused was not sentenced to direct imprisonment for being in possession of a firearm, whether it is just for a minute, for 10 minutes, for 20 minutes? And the answer is on 98. Your Worship, I have not, because most of the cases that I've seen were also not only the firearm possession case, but most of them relate is in the context of other crimes that were committed with the firearm. So the possession forms part of that. And then a sentence of imprisonment is also imposed for that. I have not come across a case where it was purely just for the possession of a firearm. So your Worship will know from reading the heads of argument, they infer differently or even say that you answer differently, which is not the case with respect. In the state's heads, they summarize the Mutlung decision, and they also deal with possession of an unlicensed firearm. The Delport decision, which I've already referred to, the gradation, the Malchus decision, and now, Your Worship, with respect, they've gone to all the cases that deal with minimum sentence provisions. So, and they even refer openly there to the Criminal Law Amendment Act, which they abbreviate as CLA, which is Malchus, the minimum sentencing legislation. It continues, Your Worship, even in paragraph 21, when they deal with Madikani at the Criminal Law Amendment Act. They go then to Dubi, which is a minimum sentence, because there was a well-planned robbery. Asmal, which we dealt with the very issue of minimum sentencing regime being applicable. And Rontlai versus the state, robbery and other offence. In fact, there were 2 robberies. He'd already had the previous convictions and he received 20 years. Sabandi versus the S, then the Tembe-Letu, the Dladla decision. But you'll see, Your Worship, even in Dladla, the serial number has been obliterated in the unlawful possession of ammunition as well as 15 years for the unlawful possession of 30 rounds. So we say they're totally distinguishable, and you'll see there, if you turn to paragraph 28, that it was a prohibited firearm, also with the serial number obliterated. And this is the general trend in all of the cases that are referred to here, Your Worship. So it would seem that they seem to have emphasized cases that dealt with the Criminal Law Amendment Act, in the Tower case, and it carries on like that with respect to Worship. But there's no case that they can point out of celebratory shots being fired and the person receiving a prison sentence. And they also refer to the minimum sentence in paragraph 36 and the Delport decision. So what they say, Your Worship, is that the court must impose a period of imprisonment, that they refer to cases that all, with respect, refer to minimum sentence legislation and are not applicable here. They say in paragraph 45, Your Worship, and this is the strongest part of the case, in this case, the state submits that due to the fact that the accused testified that he planned to possess the 2 firearms, a 9mm pistol, a handgun, and semi-automatic rifle, he emptied the 9mm by firing 15 shots, followed by 7 shots from a rifle. That there was a crowd of 20,000 people at the stadium, which included supporters, medical personnel, police officers, security guards, coupled with the fact that there's a very condensed community residing right around the stadium, are facts that places the accused in the sentence category between 7 and 15 years imprisonment. They then ask for 10 years imprisonment, and then finally, Your Worship, they refer to the Zinn decision which gave rise to the triad, and they say, lastly, the accused has treated the proceeding with such contempt, took the citizens of South Africa for fools by trying to convince all that he fired a toy gun, blamed everyone except himself for his actions, confused the law with politics, practiced all intimidating tactics by hiding behind crowds, dragged everyone to be participants in his show. The show is over. This court must send out a strong message to other would-be offenders who fire shots among crowds and endangering the lives of others, that if you commit a crime, you must do the time. And that's their conclusion there. Then, Your Worship, as I already said, they filed supplementary heads of argument last Thursday, and there's a lot of, with respect, repetition, Your Worship. We'll see. The introduction is very similar. They highlight the charges that he faces. They concede in paragraph 4, and this is where they go against their previous heads, that the minimum sentence legislation does not apply because he had not been warned accordingly. But they asked the court to impose a custodial sentence, and they do the aggravating features of the case, and they repeat everything that they said in the previous heads. There's nothing with respect new, so I don't know what was supplementary about this, Your Worship. And they then, in paragraph 9, attempt to deal with our heads of argument and to respond to the heads of argument, and they say in paragraph 9, this distinguishing feature of premeditation places this case in an entirely different category from every authority cited by the defence counsel in favour of a non-custodial sentence. In Pistorius, the restaurant incident, the discharge was negligent. In Mdantsane, it occurred in a moment of intoxicating passivity. In Falun, it was a crime of passion. None of those cases involved a public leader who planned to discharge live rounds from 2 firearms before 20,000 people as a rehearsed act of spectacle. And once again, Your Worship, I highlight, they tell you all along, treat him like a normal person, but they keep highlighting with respect that he's the leader of a political organisation and you must punish him accordingly. So it's self-defeating with respect. They then also, in paragraph 10, they have a heading beneath that 2 firearms, 22 live rounds before 20,000 people within a community. And they refer to the firearms being a 9mm handgun, Narinka SPA 24914 5.65 by 45mm, Remington semi-automatic assault rifle. But Your Worship, what they failed to record here, or even consider, they gave that back. So if they believed that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm, in paragraph 11, retains lethal kinetic energy on descent. The potential for mass casualties was real, foreseeable and scientifically established, but we have the objective fact, Your Worship, and they say that it's pure fortune, that nobody was injured and there was no damage whatsoever, Your Worship, which is a factor that this court took into account in the judgment and ought to take into account on the sentence. It's one of the most important factors we've taken into account. And that's what they say in 12, Your Worship, that no one was killed or seriously injured was a matter of fortune, not mitigation. And then, Your Worship, in 15, they say that this conduct is a harm to the values of constitutional democracy itself. And in 16, again, they say the court is therefore called upon not only to punish the accused for his individual conduct, but to vindicate the constitutional principle that public office and political prominence do not confer immunity from criminal sanction, which is the point that I'm making repetitively because they seem to go between those two approaches with respect, Your Worship. They then also refer to the decision of Hewitt as did we, and then they claim that the accused not only had an absence of remorse but also insight and accountability, and that he had maintained throughout and continues to maintain that he committed no offence despite being convicted after a full trial on overwhelming evidence, which is the issue that Your Worship dealt with on record and recorded that it was his right, constitutionally recognised right to plead not guilty. And then they say that he described these proceedings as an abuse of the NPA resources, an incompetent prosecution attributed the undisputed discharge of 22 live rounds to a political vendetta by AfriForum and others, including the President of the Republic, racism, and even the Holy Spirit. And what they say that he sought throughout to conflate the rule of law with political persecution. And they then deal with Ms. Thompson, which I don't know why they had to do this in a supplementary set of heads, but it's a lot of repetition. And this is where they made they say she made a concession in paragraph 20 that they describe as remarkable, and we say that doesn't appear from the record. We didn't have the record at the time, nor did they, so it's understandable. Maybe that is how they interpret it, because Your Worship knows we received the record from Your Worship very recently. But in 20 they say that firstly and most significantly, Ms. Thompson conceded under cross-examination that she could not find a single case in the literature where a non-custodial sentence had been imposed for the unlawful possession of a semi-automatic firearm. This concession is remarkable. It speaks not to the uniqueness of a lenient outcome, but to the settled judicial view that such offences call for custodial sentences, a view Parliament endorsed through the enhanced penal jurisdiction in FCA. Now that cannot, with respect, be correct. My learned friend wasn't aware of it, which I do concede. the more recent decision of the Eastern Cape to worship, where there was possession of an unlawful firearm. It was an illegal homemade firearm, and there was no custodial sentence imposed, and we dispute that such a concession was even made, Your Worship. We don't find it in the record. I know that sometimes the records aren't 100% accurate, but my learned friend can elaborate on that, because that is from his supplementary that's filed last Thursday. Then they deal with the issue of Ms. Thompson's recommendations premised on a characterization of the possession as brief, benign, and celebratory. On the brevity, they say the brief duration of possession is relevant only where possession is accidental or fortuitous. They say here it was pre-planned and deliberate. Benignity, 22 live rounds. They say the ballistic risk was extreme. Celebratory purpose, they say the law does not distinguish between a reckless act done for enjoyment and one done for malice in assessing objective dangerousness. The rest we say is a repetition, but then they say, Your Worship, in 22. Fourthly, Ms. Thompson's assessment of the risk of recidivism was superficial. She relied on the mere passage of time since the offence. She did not grapple with the fact that the accused, who leads a political party that has staged multiple large-scale events since 2018, has demonstrated no acknowledgement that his conduct on 28 July 2008 was dangerous or unlawful. The absence of reoffending in the interim is not on its own indicated that no such risk exists. Now, recidivism is defined as the tendency of a convicted criminal to reoffend, relapse, or go back to its way. And that's the clearest indication is looking back on time to say, did such a thing reoccur? So we submit that Ms. Thompson is accurate in that regard, and they, with respect, seem to have misinterpreted the term recidivism, and it wasn't superficial, because we look back in time, we say, were any other offences committed in that time in the past 8 years? And the answer is no, because a clean SAPS 69 was handed in, so it doesn't appear that she's inaccurate in that regard. They then respond to our submissions, Your Worship, on sentence, and they dispute that celebratory discharge cases are distinguishable. They say that you do have outcomes where there are no, I think that they say they're distinguishable. And then, as it was dealt with in their previous heads, Your Worship, they're saying Pistorius, there was no premeditation. In Mdantsane, the accused were intoxicated police officers who fired at a canoeist in a moment of madness. Fulyun was a crime of passion. Bader was a firearm and reckless endangerment, not discharge. So they say they're all different. And we say, yes, Your Worship, but at the same time, the most glaring fact, Your Worship, is they could not find one case in our whole history of all our cases, Your Worship, of shots being fired at a funeral or a celebration that resulted in a prosecution. And that's a fact that stands out on its own, Your Worship. And then they say the no harm, no injury argument misrepresents the nature and gravity of the charges. And they say no one was injured, no property was damaged. The state acknowledges this, and that this they describe as being purely fortuitous. But what they don't mention here, Your Worship, and Your Worship went through the trial, so Your Worship knows, there was not one eyewitness that came to testify before this honourable court. The state was dominus litis. If anybody was in fear, out of all those 20,000 people that they now rely upon, it was incumbent upon them, either in the trial, Your Worship, or even in aggravation of sentence, to lead that evidence, but they didn't. Even the SAPS who were on the stage, Your Worship, were not called by them to testify, even in aggravation of sentence, Your Worship. Not even the gearhouse people, Your Worship, said that they feared or were worried for their lives or ran away. No single person stood before this honourable court saying, I was afraid of being injured. I saw this as reckless, careless, and dangerous, which is something that they ought to have led if they wanted to prove that there were aggravating circumstances. They then, Your Worship, tried to fall back on their previous heads of arguments and say even where the minimum sentencing regime does not apply, the case law establishes a clear sentencing range for unlawful possession and discharge of semi-automatic firearms. They then quote our constitutional cases that we quote. The principle is clear from that from the case of Makwanyani, Your Worship, and EFF versus the Speaker. Then they turn to the personal circumstances of the accused, and they say it's a double-edged factor. It may be often a mitigation of personal circumstances, that is a public leader and member of parliament, But they say this is the most significant aggravating feature of the case. So now, Your Worship, they argue, treat him like any normal human being. At the same time, they say, no, this is the single most aggravating factor of the case. The two are mutually exclusive with respect, Your Worship. They acknowledge, Your Worship, in F, that all 5 counts arose from a single continuing incident. But they say the remaining counts serve to aggravate the primary count, not merely to establish its context. And then, in their concluding submissions, Your Worship, they go back with respect to the imperative of equality before the law. So you asked on the one hand to make an example of this accused because he's the leader, current leader of a political party. Then they tell you no. There's an imperative. You must make us all equal before the law. And they say then themselves, they say a sentence that treats his case as an exception to well-established sentencing norms would itself be an act of unconstitutional discrimination against the poor in favour of those with means and the powerful. Now what we're saying, Your Worship, is they seem to imply that to impose a fine would be unconstitutional. It's not the case, Your Worship. You can impose a fine. It's recognised even in the post-constitutional era that a fine is a punishment, as is a suspended sentence, as are other forms of punishment. They're recognised. Then they ask for the imperative of proportionality and the imperative of deterrence. And then they repeat themselves, Your Worship, in paragraph 35 yet again, where they say, and I'm going to quote because you'll see just how many times they've said this, the accused has treated these proceedings with contempt. This is from the previous head, Your Worship. He fabricated a false account of a toy gun that was comprehensively dismantled by the overwhelming evidence at trial. He refused to cooperate with investigators. He characterized this prosecution as an abuse of the NPA. He blamed VIP protectors, the Holy Spirit, and everyone except himself. The show is over. The court must now ensure that justice is done, not because the accused is prominent, but because the rule of law requires that every person who commits a serious offence faces a serious consequence. And they therefore go back to the zin as they did in the previous heads and ask Your Worship to impose. Now, Your Worship, what's lacking from all of this, and which leads into the allegation by the accused that this is an abuse of the NPA, is the objective fact, Your Worship, that we as a team and the state as a team, and I believe Your Worship too, were unable to find any case of any single individual who's ever been prosecuted for firing shots at a funeral or at an event or a celebration, despite all of us having seen that regularly on our TV, on the news, etc., etc. We therefore say, Your Worship, that a more appropriate sentence, taking everything into account, would be to take all the charges together, they arise from one incident, and to impose a non-custodial sentence which may incorporate a fine and a suspended sentence and any other order. But to incarcerate the accused, we say would be startlingly disproportionate to the offences here, Your Worship. Thank you, Your Worship.
Thank you.
No, another right of reply. My other friend's in a difficult position because his heads have been alluded to, but I'm sure he's going to add to them as well and deal with it.
Yes, and then obviously you may reply
as you wish.
if something.
I think Mr. Guy Toby will do the reply also, with your leave. Thank you.
Advocate Otis, there's just one aspect that I want to ask since you've raised it now, and I've read it in the heads and heard in the evidence of Ms. Thompson, and that is the part of the firearm being handed back before the court passed judgment. That is not within my knowledge. So,
it is, because it's in the report. She testified.
No, it is in a report. I'm saying it's not within my knowledge. I'm hearing it from the defense.
There was no evidence. No, there was evidence that she testified to that.
No, I don't
it's
think
in the report and it's in the testimony, and Your Worship, it's a logical conclusion. My learned friend, who was in court and would be aware of it, never disputed it once.
Yes, no, maybe I'm not. I heard her saying so. There's evidence by the defense regarding that. I'm just not sure where it's coming from. You don't have to. I accept it's there, and as you say, it wasn't challenged, but it's not within the knowledge of the court that it was returned before judgment.
No, it is, Your Worship. It's in her report. She was led on it. No, I was also astounded by it, so you'll find I've given Your Worship the page reference
No,
and the
I've
report
seen it.
reference.
I know it's there. I do confirm it is contained in her report and,
had
in
it,
her evidence.
had it not been the case, Your Worship, my learned friend was obliged to challenge on it and he didn't. So it's an objective fact and it's evidence that was led before this Honourable Court. I don't know why there's a noise, Your Worship, and I don't align myself with it.
No, it's the
So let
same.
me repeat what I say, Your Worship. She testified, as Your Worship knows, it's in her report, and my learned friend was present and never ever cross-examined her on that aspect. So, with respect, in our submission, it's a proven piece of evidence before this Honourable Court.
Look, I hear you, I agree, and then I saw it in your heads, and that's why I thought I'll ask, because I'm not sure what the source of that information is, but it's neither here nor there. As you say, it's on record. I'll hear if the state has any reply to it, but it's not. Thank you. It's so noted. Thank you. All right, Advocate Caesar, are you ready or?
I think we must get this over and done with. Thank you, Your Worship. I'm ready.
I know it's inconvenient, you don't have to move. We do have lady staff here who are requesting a bathroom break, which is 5 minutes. We can return within 5 minutes. Don't want to put anyone on the spot, but I'll just leave all my stuff right here, so I don't have to carry anything. Don't know who else, but sorry, the public, the gallery. If you do need to go out to facilities or water, etc., just please stick to the time frame so that we are back in time to proceed, because it's a lot who has to go out and back, and then 5 minutes becomes 15. So I know everyone can't manage in 5 minutes, but I'll be right here. Sorry for that. Let us just allow everyone that comfort. Okay, so it's now, let me say should we now just do the tea adjournment and get it over with? Is that fine? Do you want us to do the tea adjournment now? Then I return at exactly 11:45 and then we go right through. Fine. I can't hear. The defense, is that in order? I can't hear. Okay. Court will adjourn until 11:45. Thank you.
And the guilty verdict being, among others, for discharging a firearm at the Sisa Dukashe Stadium. Now, Advocate Rhodes has, among others, taken the time to take Magistrate Toinette Olifiel through a number of cases of discharge of firearm which didn't attract incarceration or direct imprisonment. Among those cases that didn't attract incarceration being that of Oscar Pistorius at the Tasha's restaurant. Many would remember that. Now, that specific incident, as many would remember, was exactly a month before Oscar shot dead Riva Steenkamp. A friend of Oscar's had been showing him his gun. Then Oscar discharged the firearm inside the restaurant. Of course, no incarceration there. The friend also indicating that he had said it was loaded, but Oscar having insisted that he didn't hear that part, that the gun would have been loaded. Now, today they seek a deviation, as we've heard from Advocate Rhodes, from the minimum sentence given that, among others, he says there was no harm to anyone nor damage to property. Then also taking the court through the state's arguments that they say custodial sentence is inevitable on their part. He highlights that he views that somewhat of a contradiction, where the state says Malema must be treated like any ordinary citizen and not favored in any way. Then the state, in the next line, says as a leader of a political party in society, they would be demanding a harsher sentence, something that he says is quite contradictory. So the state doesn't know whether they want him to be treated like an ordinary citizen in arriving at a sentence, or he must be treated as a public figure. He goes on to crystallize this, saying, in essence, though, the state is saying political prominence must not be viewed as something that confers immunity from prison, but also the state goes on to say political prominence must guide the court in arriving at a sentence, because at least that's what the state believes society would want to see in this respect, to almost restore their faith in justice, that political prominence does not afford you any level of favor in any kind of way. Now, Advocate Dredd is then also going on to highlight that the state brought no eyewitness in their case, and being dominus litis, of course, Latin term for the one who brought the case before the court, that as dominus litis in this matter, they ought to have led evidence such as that of bringing an eyewitness who would have stated that they feared for their life, they were in danger, to almost prove aggravating circumstances in that respect. But he says this was something they opted not to do. So quite a lot of points being highlighted there by the defense today. And of course, the brief adjournment, they should recommence at 11:15. As you can see, live visuals there of Malema being flanked by his legal representation. As you'd see there, Advocate Rhodes wiping off some sweat. It's been a difficult day at the start, of course, understanding the importance and gravitas of this moment for EFF leader Julius Malema. We are running a poll today to get a sense from some of you and bring you into the conversation, given that this is the pre-sentencing hearing of a political party leader. We're asking, what do you think will be the sentence handed down to Julius Malema? Suspended sentence, we're getting 67% of you at this point saying so. Less than 12 months jail term, 9%. 3 to 5 years jail term, 12%. Maximum sentence, 13%. Well, 3 to 5. At the least here, minimum sentence being 15 months, of course. Pardon me, 15 years for that specific sentence. So as we can see, it seems suspended sentence is garnering a lot of support, or if we can say that at least a number of you are of the view that in this respect he would get a suspended sentence. But do continue to engage with us on our social media platforms, because beyond knowing that some of you, 67% of you, view that he would get a suspended sentence, it would be interesting to hear what informs that. Is it because you believe that there were no aggravating circumstances, as his lawyers are saying, or you believe that he should be treated as an ordinary citizen? And in that respect, it is warranted that they deviate from the minimum sentence. So the reasoning behind that decision of suspended sentence, or your views of suspended sentence, would also be quite interesting to share. So do interact with us on our social media platforms. Just also bring your attention to another story that we continue to follow. Of course, it's the Madlanga Commission of Inquiry. As you can see there, the commission chair currently addressing the witness who remains on the stand. It's day 2 for Julius Mkwanazi, suspended EMPD Deputy Police Chief. Second day on the stand today. We'll continue to oscillate between all those proceedings, because a number of stories on our watch today. But we'll take a quick break and then we take you back to other news. where in the discharging of a firearm, it didn't attract direct imprisonment. But we do know that on your side outside, you've continued to engage at least with EFF. Now you are joined by the spokesperson of Mr. Mdantsane.
And that's right, Mfunda. Welcome back here to the court precinct here in KuGompo City. And of course, as you say, the proceedings continuing inside court. But of course, outside court, we have throngs of EFF supporters waiting out here and in part trying to listen to the proceedings from inside. But it is a bit of a difficulty trying to get that sound and get it through so that the people out here can listen. But they are waiting patiently, Mfundo. But of course, you would remember initially, Mdantsane was charged alongside Julius Malema. Now, the evidence, the video evidence that was relied upon clearly showed Mdantsane bringing the weapon that was ultimately discharged and, of course, handing it to Malema, taking it back and then moving off. And subsequently, when the matter was heard, we saw that Magistrate Twanet Olivier had then discharged all of those charges against Mr. Mdantsane. So he was acquitted entirely. But of course, so many questions remain around that particular aspect of this case. Julius Malema in October last year, that's October 2025, was of course found guilty on a raft of charges that include the illegal possession of a firearm, also illegal possession of ammunition, discharging of a firearm in a built-up place, reckless endangerment are some of the charges on which he was found guilty. And of course, we were here in January, and at that point, it was, of course, for a pre-sentencing hearing, which of course continues on the inside here today, Mfundo. But I want to bring in Kirsten McLeod, the spokesperson for Mdantsane. And Kirsten, thanks so much for speaking to us here on the SABC News. But of course, the question on many people's lips is, of course, how is it that someone like Mr. Snyman, who was clearly an integral part of what these charges center around, to have been acquitted while Mr. Malema is still facing charges?
You know, I think for Mr. Snyman, he's suffered an immense amount of physical, emotional, and that is why he is charging the NPA and the SAPs. And we're still waiting for their response. And it's been more than 30 days that we've given them, and the statutory period is now expired. And we are now going to action the papers. And if they,
You know what? I'm going to ask you just to pause, Mfundo, as I pause Kirsten there, because sometimes it's difficult to hear yourself think over the noise. So just waiting for the crowd behind us who have come in chanting to just settle down, and then we'll continue, because among other things, as we understand, is that Mr. Mdantsane is, of course, suing the state with regard to what has taken place here. So we want to get those details, but of course, trying to also just contend with the noise. But Kabi, what I'm going to do is I'm going to try and see if I can move with Kirsten. So we try and move slightly away from the noise. And if you can just follow us as we do that, because this, of course, is what happens during a live broadcast where things don't always go according to plan, because it's a fluid situation. But just moved slightly away, and easier for us because we do this on a daily basis. But I can see Kirsten actually struggling because you literally can't hear yourself think. But Kirsten, I was just, talking about Mr. Snyman and him being an integral part of this case at the beginning, but has subsequently, of course, been acquitted on all charges. And people are questioning that, asking how was that possible? And also, as I understand, the weapon was actually handed back to him even before the final determination.
Yes, that is correct. Once Mr. Snyman was found not guilty of his charges, he did come and collect the firearm, and that is obviously before Mr. Malema has been sentenced.
Did he find it strange that he was acquitted and Mr. Malema continued to stand trial?
I don't think he found it strange. I think for him, he was not guilty. They had no evidence against him. So, I think it speaks for itself.
So that's interesting because when you say there was no case against him, if you look at the charges on which Mr. Malema were found guilty on, the illegal possession of a firearm, the illegal possession of ammunition, and reckless endangerment, the discharge of that firearm in a built-up place, Mr. Adrian Snyman was an integral part of that whole process. He brought the weapon.
So I can't comment, obviously, for Mr. Malema. I think that's for the EFF, the Economic Freedom Fighters, to comment on his behalf. But I can speak, for Mr. Snyman that he is obviously happy with the results on his side and being found not guilty. But for Mr. Malema, unfortunately, I can't comment on that. So.
I do understand that Mr. Snyman is proceeding with legal action against the state. Are you able to share more of that with us?
Yes, I can. So we are still waiting for the NPA and the SAPS to respond to the written demand made for payment for more than 20 million rand. This is obviously as a result of the malicious prosecution against Mr. Snyman. The 30-day period that we gave the NPA and the SAPS to respond has now expired. So we'll be actioning papers that will be shortly sent. And if they fail to respond, then we'll have to apply for judgment by default.
So that is the latest course of action. So this is where we're going to leave it for now. And this, of course, Kirsten McLeod, thanks so much for your time. Spokesperson for Adrian Snyman, who was initially charged alongside Julius Malema. But you heard he is now pursuing a prosecution against the state for a malicious prosecution, demanding 20 million rand. And as Kirsten McLeod just said, the state had missed the deadline to respond to the initial communication in that regard. But of course, we'll wait to hear more. And of course, people here milling around somewhere. Let's find out where he is. Sam, over to you.
Indeed, Sakina, we are outside this KuGompo Magistrates Court where EFF members are gathering here outside in support of their leader, Julius Malema. They are in anticipation of what will happen during this mitigation of this possible custodial sentence that Julius Malema might get of about 15 years that ultimately see him being incarcerated. But he has said that he will appeal this particular judgment. Let's just take in some net sound. Those are essentially EFF members who are gathered here outside this court, here to support their leader, Commander-in-Chief Julius Malema, in this particular case that he is facing. We are going to walk around with my colleague just to show you these members who are waiting patiently for court proceedings to conclude today. The state does feel as if Julius Malema has not been remorseful on this particular gun charge that he is facing. If you look at these particular matters that ultimately he is facing, they relate to the contravention of the gun laws within the country. As you can see, many are waiting patiently, sitting here. Some are sleeping after that particular night vigil that they have had. They are resting at this point in time. After the night vigil they have had, they are sitting here quietly, listening to the court proceedings as they've currently adjourned at this point in time, and they will reconvene at about 11 o'clock in court after the break is done. But the EFF leader is set and has said that he will appeal this particular judgment once it is done and dusted, and he will seek to take it to a higher court.
All right, there you have it there. SABC News political reporter Samkele Maseko just bringing us live visuals from his vantage point as he's indicated there that the EFF leader is still adamant that he will be appealing the case, but also quite important to note that conversation between Sakina Kamwendo and the spokesperson of Adrian Snyman. Of course, that's the bodyguard that was acquitted. We have since heard now established that Adrian is suing the state for 20 million rand, and for him, he believes this was malicious prosecution. And just on quick perusal of malicious prosecution and the elements that one would need to meet to actually succeed with such a case, while Googling there, I quickly saw that what they really would need to prove was that the state lacked some sort of reasonable or probable cause in initiating the criminal proceeding. So one wonders if that one would succeed, given that there was a firearm that did belong to him that was then returned to him. So very interesting developments there around the decision to sue the state. On your screen, as you can see there, we split the screen into three. The main visuals you're seeing now is of the poll that we're currently running. We're asking you, what do you think will be the sentence handed down to Julius Malema? Of course, quite a topical conversation in South Africa right now. What we're seeing on our screens, some of you, 67% are saying suspended sentence, 8% are saying less than 12 months jail term, and then we've got 3 to 5 years jail term, that's 12% of you who have participated, and maximum sentence is 13%. Now, judging by those polls, to a suspended sentence. Taking you back to some of what we've heard, at least from the legal representatives of EFF leader Julius Malema, that's Senior Counsel Advocate Hodes. He's gone on to indicate that for them, they're adamant that in this respect, it would be warranted to deviate from the minimum sentence because, among others, no eyewitness was brought before the court. That as dominus litis, which would be those who brought the case, the state, they had the opportunity at any point to have brought in an eyewitness from the Sisa Dukashe Stadium on the day in question to at least speak of the fear that they felt when a firearm was discharged, but they opted not to go that route of bringing an eyewitness, which would have assisted at least in aggravating circumstances. So they believe that on their own as the state, they would have essentially sabotaged their case insofar as it relates to perhaps a maximum sentence in this respect. That given that there was no eyewitness who would speak to reasonable fear that they would have had at the time, it would warrant some sort of a deviation. Beyond that, they're going to say that damage to property was something that was not spoken of because there was no damage to property. And then he goes on to speak about what he would consider, or if you will frame it as double speak of the state in this respect. He says in one respect, you've got the state in its papers that emphasizes that Julius Malema must be seen as any citizen of South Africa who must be equal before the law. And then in one vein, they go on to state that he is a leader of a political party and it would be important for the court to make an example of Julius Malema, something that Mr. Hodes has stressed at length. He has spoken about this ad nauseum, that they've got to pick a side, that it's either they want him to be viewed as a prominent political person who must then be sanctioned accordingly, or he must be viewed as an ordinary citizen. And if it is for him to be viewed as an ordinary citizen, they've taken the court through a number of cases that didn't attract incarceration, cases related to the discharging of a firearm, and would have stated a bit earlier on that Advocate Hodes went on to speak about the Oscar Pistorius case where he discharged a firearm at Tasha's restaurant. There was a packed there were packed patrons on the day, even children quite close by. Oscar Pistorius had indicated at the time that he didn't know that the gun was loaded. It was the gun of his friend who had passed it to him underneath the table. So most certainly they've brought in a number of case law to try and buttress their case here to say this warrants a deviation from the minimum sentence. As indicated, 11:15, court resumes. We'll take you back there sharply. But as you can see, a number of EFF supporters still on our visuals there. They remain relentless. They are there for the full day to support their leader. They are united in song. And the other live visuals that you're seeing there are from court, of course, awaiting the start of proceedings yet again. Let's quickly now take you to other stories. All right, those are visuals there from the Mdantsane Commission of Inquiry. A state
is interfering with the recording at all. We hope not. And then we'll be ready for you, Advocate Sisa. Please be seated, Mr. Malema. You may proceed, Advocate Sisa. Everyone from the defense also ready to proceed? Thank you.
Can you also just inform everybody again that the cell phones must be switched off or on silent?
The gallery, you heard that? Is our interpreter here? Ms. Mabwa, please.
As the court pleases your worship. Not acting your phone, cell phones off, possibly.
Just a minute.
Thank you, Worship. Worship, I don't know how counsel expect me to impress my bosses as if he has done half of my job for me. One thing is certain, I'm not going to pay him 1 cent for that, Worship, for doing or attempting to do my work for me.
Please go ahead.
It was when I was at the magistrate's course many years ago. They had this 3D dimension on the board where we each were required to say what exactly was on that particular 3D dimension. Some saw elephants, I saw a head of a man, an old man. Even some saw a lion, some saw 3 heads. The point that I'm trying to make, Your Worship, is that we're looking at the exact same set of facts with different views relating to that particular fact. That is the court's duty to find which one is the more plausible argument. It's not for me to minimize counsel's argument and vice versa. There's just 2 aspects that I need to rectify right from the beginning. The issue relating to the filing of heads. My heads, I confirmed, was filed on the 1st of April. The issue that I need to address is the condemnation issue, because I did call Mr. Kwanazi on the 31st informing him that my heads are ready, it's ready to be filed. I wasn't in office, I was on the road, and I did not want to send unsigned heads, which he confirmed that there will be no issue. Why counsel raised it like I had to apply for condemnation? To me, that is sufficient. It was filed first thing on the 1st of April when I got back to the office. The second issue that I also relating to the condemnation, I did not read counsel's heads on the 31st. The reason being, as already explained, I was on the road, I was not in office, I was unable to read it. That's the reason why I contacted the attorney, Mr. Mkwanazi, because I did not have any other person's number. It's my view to the heads of counsel and the supplementary heads. There's no need to apply for condemnation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. it was given back to accused number 2 on the day when he was found not guilty. There was a prior agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there is no need for the firearm to be kept further. If I might read, just to assist counsel, what this particular section says relating to that. The lights or what?
I think it's the bright light behind you may cause a glare, I'm not sure.
Can I ask my learned colleague, because let's, so I would actually ask counsel to read that particular part for me. You must read section 30 and then section 31, 1, because I can't see it.
Just borrow someone's tickles advocate, Caesar.
It's time, it's time.
It's time that you go and get spent. Oh, he's got them there, look. Sorry. Now we are in a spectacle. All right.
Much better. Section 30 deals with disposal by police official of an article after seizure. A police official who seizes any article referred to in section 20, which we know it's articles which they lawfully entitled to seize from an accused or a suspect or any person who is suspected to have committed the crime. To whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interest of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen with the consent of the person from whom it was seized, deliver the article to the person from whom, in the opinion of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to read the last one, C. I'm going to go to section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in section 30C, or if it appears that such article is not required at the trial for purposes of evidence or for purposes of any order of court, the article shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it. We had no need for that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and then it be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup, because we were perfectly within our right to return it. The investigating officer has retired. If that article went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the same storm in a teacup that was made about the laptop where the video evidence was stolen, despite the fact that it was kept on another hard drive. The laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there, it was already collected, just as the article prescribes. Since that issue now has been dealt with and the law allows us to do so, I want to deal with the issue relating to Section 9 of the Constitution because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offences, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law. I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the street. And so far as sentencing was concerned, the court is well aware that courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest of society. I'm not going to go through my acts page by page, but we have referred to State versus Banda and others.
So I follow you. Are you doing a combination of first and second, or which one are you busy with now? So I can
with page 2.
Of the first one.
Yes, it's the first one.
Thank you. Just so I can follow. Thank you.
You see, the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson. I will deal with the flaws of her evidence when I refer to my supplementary heads of argument. It seems that basically she relies on those factors that the accused did not injure somebody, that he possessed the firearm for a short period of time, and then she made a recommendation because you also have a soup kitchen that he is responsible for, that he should get a non-custodial sentence. I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks this morning. I am going to go through it, but I will deal with it briefly, just briefly. If the court allows me time to read it properly, I can produce many similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I do deem it necessary to hand this particular judgment up by the DJP, the Deputy Judge, now retired Judge President Mdantsane, where he has an opposite view regarding firearms. The matter of, it's an appeal matter, a full bench appeal judgment. The matter of Romeo Jansen, the case number, it's CANR 220/18. I just want to see the date when the judgment was delivered on the 29th of August 2019. This is a full bench matter where he held the exact opposite view of what Justice Brooks held regarding the possession of firearm. And this already outweigh the judgment as counsel has handed up of Mr. Nolan Linzima Ndlela, because this is a full bench judgment of the same division. I'm going to give counsel a copy as well, if I may hand it up for the court's benefit. The fact that their judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms. We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court. So the reason why these judgments are relied on by the Supreme Court of Appeal, because of these different judgments from different divisions talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing. He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one in that Romeo Jansen appeal matter. Your Worship, I want to be upfront that the state is seeking a custodial sentence, and if we can get the maximum sentence of 15 years, counsel correctly said that we do not rely on the Minimum Sentence Act. We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose at least a 15-year term imprisonment. Without being prescriptive, it is correct that the custodial sentence will send out a clear message. Counsel referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw it on television once, is the one that was highlighted by the Deputy Mayor, I think, of the Nice-Now George municipality. The outcry because of that shows that should not be tolerated in a civilized society, where people's lives are placed in danger for people who are in a celebratory mood firing shots. And in most cases, these people are unqualified to fire such shots. In this instance, accused did not just fire one shot and left it at that, which we can consider to be an accident. He was malice, to say the least. His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdantsane, which we know is one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdantsane. It was by the grace of God that nobody got hurt.
I think I repeated that. I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet. I'll order you to leave. There won't be a choice. Understood? Please interpret, Ms. Magwa.
njengoba yayishilo ke nge-23 yayicacisa umba wento bana bakuphinde kwenzeka okwenzekayo ayizothi abantu okanye bayiyalele into yoba mabathule okanye bazole enkundleni eyothi bakhuphe abantu abenza le okwenzekayo phakathi enkundleni ngoku.
You may watch outside if it's going to cause a delay in or noise. Ms. Magwa?
ithi inkundla iyacela ke into yoba oku kungabikho kwenza into yoba oku kube kukubambezelayo ngokuqhuba kwecala eli.
Advocate Sisa, you may proceed.
Thank you so much, Your Worship. The accused is a political leader. He's got a huge following. Young people emulate this type of behavior. What he doesn't realize is that he already opened a Pandora's box where he creates the impression that this type of conduct is acceptable. What did Pastor Borodin do? He grabbed the firearm, ran to a school, screamed it was a toy firearm. The deputy mayor of the Naisla George municipality fired shots, screamed it was a toy firearm. That's the president that he said. That people think they can get away with doing these type of offenses. Courts sent out a clear message that such barbaric behavior should not be tolerated. Accused is a member of parliament, a lawmaker. Yet he's the one that broke the law. If it was anybody else, he would have screamed that that person should go to prison. But now the foot or the shoes on the other foot, he's screaming, give me a custodial sentence. Council already mentioned what I was about to say in most of these cases. But what I wanted to read to the court is a case on paragraph 4, on page 4, paragraph 10 of my heads, of argument, which is one of State versus Lister. The citation is in my heads of argument. This issue particularly deals with Thompson's evidence and how the court should view such particular evidence. I want to quote, "I remain unpersuaded by the submission in counsel's heads of argument that the court should have adopted an opinion of Dr. Sidley that a goal sentence would undermine the treatment to which she would have to submit herself. Prison, one knows, is not a congenial place, and the conditions may well be less than ideal for psychotherapy. But then a prison is primarily an institution of punishment, not a cure." As the court of quo was at pains to point, the approach of a sentencing officer is not the same as that of a psychiatrist, and if I might add, also a probation officer or a social worker. The sentencing officer takes into account all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with the diagnosis and rehabilitation. The psychiatrist is concerned to focus on the well-being of an accused at the expense of the other aims of sentencing, such as the interest of the community as a distorted process, and to produce, in all likelihood, a warped sentence. Now, I went through the Oxford Dictionary to try to understand what this word warp means. It's something twisted, bent, or misshapen. It's something diverted from its original form. It also refers to a distorted, and I borrowed the glasses again. It's regarded as abnormal. I'm definitely going for an eye test after this show. I've been in denial for a while. It refers to a distorted, abnormal, or perverse mental state or sense of humor or twisted moral values. If the accused get a non-custodial sentence, but this is basically what the law now would go to. It will tell people it's okay that if you fire shots, whether it's 1 or 2 or 10 or 15 or 22, it's fine, you'll just get a fine, non-custodial sentence, because this is what the type of sentences the courts are imposed. Whereas it's my submission, it's not. All the cases that I've listed in my heads of argument, all the accused got direct imprisonment. Counsel also stated that I referred to the Minimum Sentence Act. I concede the accused was not warned. The fact of the matter is, the point that we were trying to make, that the Minimum Sentence Act and the Mahas judgment is at pains to explain that court should impose standardized sentences, whether it's minimum over 15, 15 and up, or maximum 15 and down. The sentences should be more or less the same, depending on the facts of that particular case. I did not refer to Mahas, of course. I want to draw the court attention that he should get the minimum sentence, which is 15 years and above. I drew the court's attention to the Mahas case to inform the court that that's basically what it boils down to, that for certain type of offences, standardized sentences, whether it's minimum or maximum, should be imposed. That was the intention of the legislator. In State versus Delport, I'm at page 5 of my head. Paragraph 14. I quote, "There will undoubtedly still be a gradation of seriousness attached to the unlawful possession of firearms. In this respect, much will turn on the circumstances in which the unlawful possession occurred. There will be cases in which it will be evident that the possession, although unlawful, was relatively innocuous, and that the weapon was unlikely to have been kept or used for any nefarious purpose. It refers to a sentence of 15 years imprisonment in such cases would clearly be disproportionate and irreconcilable with a constitutionality compatible implementation of the prescribed minimum sentence regime. There will often be an evidential burden on an accused person to give an explanation showing that his possession of an unlicensed firearm was relatively benign. That will be all the more so when the weapon concerned is a prohibited weapon. We know that these were 2 firearms that were fired. There was a submission that nobody came to come and testify. Already, we argued this point already. We had all the evidence, the video evidence was the silent witness. It gave us everything that we needed to know. No witness would have been able to describe everything that we saw on that video. To rely on the fact that no witness came to complain and so on is neither here or there, or that we did not call any witnesses in aggravation of sentence is either neither or there. The video speaks for itself. They say a picture speaks 1,000 words. This is one of the incidents. I always have an issue when I see words like innocuous and so on. I'd like to consult the dictionary to understand what is this person trying to say when he uses words like that. The word in this innocuous, in this context, is meant not harmful, injuries. It describes something safe, inoffensive, or unlikely to cause disapproval. It often refers to remarks, behaviors, or substances that seem harmless but may not be. Synonyms include harmless, safe, innocent, inoffensive. We know for a fact that this firearm was not fired, both of them were not fired innocently. This accused testified he planned it, and when asked why did you choose a particular direction to fire, he says, don't tell me how to fire a shot, I can fire it even from underneath the stage if I feel to do so. It is not innocent. His intention was clear. He was going to do whatever he wanted to do, regardless of the circumstances and the situation and the danger it might have caused to the people around him. It was on the video, it was clear people were running. We disputed it until the last minute, but the evidence was there, we've seen it. There were 7 people in the direction, 20,000 right around where he was standing. For him to rely on the police that did not charge him and all that, that's an issue that needs to be dealt with by the police themselves in their internal investigations. I've already highlighted to this court why I referred to the Malgas case. And just to be clear that it is against this background that sentencing for firearm-related offences in terms of the minimum sentence regime must also be viewed. The question arises as to whether a standardized and consistent result, as was envisaged in the Malgas case, has indeed been achieved in respect of sentencing for the possession of semi-automatic firearms. We know that this one was an assault rifle, despite it being semi-automatic. Its size of the ammunition is dangerous. It's bigger, it's more powerful, and could have had fatal consequences. So the Supreme Court of Appeal referred to the tendency of the courts to use, even if only it's a starting point, historical sentencing patterns as a provisional standard for comparison when deciding whether a prescribed sentence should be regarded as unjust. Again, like I said earlier, it's neither whether it's a minimum sentence that's applicable or maximum sentence, but a standardized approach to sentences for certain offenses. I've referred to all the judgments that counsel have assisted me: Marikane, Asma, Ronfly, Sibanda, Gladla, Lahi, Vadbui, Glodlo, Tau, Nkobo, the judgments that is closer, in my view, to more or less the same similar circumstances, not the firing. I don't want to be misunderstood when counsel reply. It's not the firing of the shots for celebratory purposes and so on. I don't want to be misunderstood. But what I understand, what I want to point out, these people did not have the firearm for long periods of time. I have referred to it in my cross-examination of Ms. Thompson. It's the matter of State versus Swart, where the appellant was convicted on 2 counts of unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts in view of the fact that the appellant had offered a denial of possession, which the denial was found to be false, which is the same as this instance. He said he had a firearm, he said it's a toy. He still maintains it's a toy, regardless of the evidence, already overwhelming evidence proving otherwise, that this was indeed a real firearm owned by the owner, which we gave the firearm back to, which was ballistically linked. Back to after he was found not guilty and discharged. And furthermore, that no mitigating circumstance in relation to his possession could be inferred. The court held in the Swartz case that there was nothing to place his unlawful possession of the firearm in a less heinous light than that which motivated the lawmaker to lay down a minimum sentence of 15 years. However, on a further count of unlawful possession of a semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. This gentleman had 2 firearms. Ms. Thompson testified, said, 2 firearms, not taking into consideration, even when it was pointed out to her that the accused fired with 2 different caliber firearms, which he denied that he knew that the one was smaller or bigger, something that was so obvious to see. I don't know firearms well, but you know one is a rifle, the big one, and one is small, it's a handgun. In this regard, the court held that the state accepted the appellant's version to the effect that he fortuitously came across the firearm in a rubbish dump and was apprehended the same day. Here, Mr. Thompson was saying, we didn't know how long did he have it, and all the fact of the matter is, a day has got 24 hours in it, and he was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made in the spur of the moment. Furthermore, it was held that the appellant did not have the firearm in his possession for a very long before he was apprehended. He didn't have it long, same as was alluded by Ms. Thompson, yet this is the sentence the appellant was given. One was 15 years in respect of the one firearm, then on the other firearm, the sentence was reduced to one, my memory serves me correctly, of 7 years imprisonment. The court held that if the circumstances of the crime were such as to make a sentence of 15 years imprisonment as proportionate. That was the one that he did not have for a long time. The other one, we didn't know how long he had the firearm in his possession. What I want to point out in this particular matter, it's not said whether he fired shots with this particular firearm or not, or whether he used it in the commission of further offenses. My memory serves me correctly, Counsel Mr. Lukaitobi did point out that matter. Is just I can't remember what exactly was said regarding that particular point, but the fact of the matter is that he did not have the firearm for a long time. So State versus Delport, although dealing with a fully automatic firearm, Benzo J expressed reservations about the suggestion in some judgments that the possession of a unlicensed firearm should be treated as serious only if the weapon had been used for the commission of the offense. The point that I just raised just before this, it looks like the impression is created that if you have a firearm in your possession, you should commit other serious offenses for you to qualify for a 15-year imprisonment, which is not the intention of the legislator. That's why the Firearms Control Act was enacted, because of the seriousness, and that Parliament deemed it necessary, the legislator deemed it necessary to make a specific act for firearms because of the serious nature that it poses. The legislator did that in order to single it out for harsh punishment. You are already guided by the cases in the Supreme Court of Appeal. You don't need to really consider all the other cases, whereas there's already authority from the Supreme Court of Appeal saying that harsh punishment should be imposed. In both Thembaletu and Rontlai, the Supreme Court of Appeal upheld the minimum sentence for the possession of semi-automatic firearms. So in cases where an accused is convicted of a standalone offense of unlawful possession of a semi-automatic, the courts are taking an increasingly unsympathetic stance towards offenders, and terms of imprisonment to the range of 7 to 10 years imprisonment are commonly imposed. In addition, the accused's personal circumstances, one of the most important factors in deciding an appropriate sentence is his explanation as to how the unlawful possession came about. What did he say? He's planned it all along. Him and the EFF planned this all along, that this is what they're going to do for show, to entertain the crowd, not taking into consideration the consequences it might have caused. And it's no wonder the accused went right to the right side of that stage, firing those rifles, realizing there's only a minimum of 7 people that were standing there. It seems that the judicial sentiment increasingly does not support the view that possession of an unlicensed firearm should be treated as serious only if the weapon has been used in the commission of the offense. And in this case, we know for a fact that he did not, he used it. He was found guilty of all the other alternative counts, or the other counts, because he has used that. He was charged for that, and he was convicted of those offenses. I've already alluded to the fact that there were so many people there and the danger that the accused posed to that community, his supporters. "15 years imprisonment in light of these aggravating circumstances and factors that I've already pointed out to the court, without being prescriptive, the court, and in respect of the possession, unlawful possession of a firearm, the accused should have actually been charged being in possession of at least 22 of those live ammunition, because logic dictates if one of those, when linked to that firearm, it should have been 7. Logic dictates that the other 6 that went out before that was also live ammunition. In respect of count 3, 4, and 5, the state will submit that fines may be imposed on those sentences. The state will not impose such type of sentence, and that these sentences, because of it's in a single event, different counts arising from one single intent, that these sentences may run concurrently. I know counsel said this already when he read my head's paragraph 47 on page 30, as I was concluding, that the accused have treated this proceeding with such contempt. He took the citizens of South Africa for fools, that he tried to convince everybody that he fired a toy gun. Everybody can see that it's not a toy gun. He blamed everybody for his actions, confused the law with politics. He practiced all intimidating tactics by hiding behind crowns. Dragged us to be participants in this show. It's time for this court to tell him that this show is over. Court must send out a strong message to other would-be offenders who fire shots amongst crowds and endangering the lives of others, that if you do commit the crime, you will do the time. Counsel referred to the supplementary acts as a repetition. did point out that the authorities that council referred to, other than the one that they gave us this morning, that Makmoliana versus the EFF speaker, for a broad constitutional proposition about value of liberty in the role of the court. I submit that these authorities are entirely inapplicable to the present sentencing inquiry. It's not applicable, it deals with the death penalty. We are not seeking the death penalty. Its ratio has no application to the imposition of a proportional custodial sentence for serious firearms offenses. It doesn't even relate to firearms. It concerns a constitutional crisis involving Parliament. Observations about the rule of the courts as a stabilizing force support the state's position. Courts must uphold the rule of law and the principle of equal treatment. Mr. Swartz was sent to prison. The other gentleman I referred to also was sent to prison. How fair will that be? Will that be a consistent, standardized approach? If a non-custodial sentence, what must Mr. Swartz think when he hears or sees that the accused, because of his standing in society, the fact that he's famous, that he did not get a custodial sentence like the ordinary man on the street? It's my submission that will be really a discrimination against the poor in favor of those powerful. In so in a way, it affirmed the constitutional value of individual liberty. The state does not seek to ignore that value. It submits that liberty, properly understood, must be balanced against the rights of 20,000 persons whose safety was deliberately imperiled, and against the rights of society to equal and consistent application of the criminal law. Council said that I asked one thing and then I referred to another thing. That's why I specifically said in my head that it was a double-edged sword, and the court must understand it in that way, that the 7 years is for an ordinary man. Above 7 years and up, it's because of his position and the precedent that he created by doing such. Due to the case of Pretorius was never charged for being in possession of a firearm. He was charged for discharging a firearm in a restaurant of 200 people. He was charged with unlawful possession of ammunition and not possession of firearm. For the defense to rely on that issue for the firearm related offense, it's displaced. Because the issue he was imposed that type of sentence for that discharge in a restaurant. If you multiply, I don't know how my account, that was 100 times more. In this case, Pretorius fired shots accidentally, and he was imposed a suspended sentence. In contrast with the accused who fired, according to him, deliberately so, says he can fire anyway he feels deems it fit. Here this man was apologetic because he knew he was not supposed to do that. In this case, the accused says, I can do as I please, don't tell me how to conduct my business. So the 200 people that were there, multiply that by 100, then we'll get to 20,000 people. That's how serious this was. Oscar Pretorius 200, he accused fired 20,000 people plus excluding the community around the Mdantsane area. So the aggravating factors, just to conclude, that the court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that she can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do a job, just to compile a report for the purposes of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report because she was paid for it. His absence of remorse, insight and accountability. Until today, he still doesn't see what he did, what danger he posed, and what the consequences could have been. His position as a public leader and a role model to the young and to society. The fact that he's a lawmaker, breaking the law. The fact that 2 firearms were used and live ammunition were fired. Not once, like in Oscar Pretorius, not twice, but multiple times. The degree of premeditation involved and his deliberate conduct puts him in the category for 7 to 15 years. The court imposed the custodial sentence would satisfy the principles as set out in State versus Zen. And the court would do its constitutional mandate of equal treatment before the law and will serve the legitimate and pressing interest of a society that has a right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, unless there's anything else the court wants to hear.
Thank you, Advocate Sisa. Now, I just want to get the charge sheet and endorse. I'll be with you now. Advocate and Kopa.
just one issue that I also need to put on record that Mr. Snyman, the state considered that it did not prove its case beyond reasonable doubt, that it was unable to show in the video or see in the video that it was Mr. Snyman that gave the firearm to Mr. Malema. That part was inconclusive, and that's why the reason why Mr. Snyman was acquitted. Thank you.
Your Worship, thank you. I have 5 points to reply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused, and this is the crucial part. And the rifle was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. That's the first part of the source. Then, if your leadership then goes to the transcript of the evidence of Ms. Thompson at page 35, at line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. Now, why does this matter? It matters because the forfeiture of firearms that are used in the commission of offenses regulated by the Criminal Procedure Act. My learned friend has already referred us to section 30 of the Criminal Procedure Act, but your leadership will discover that section 30 is actually inapplicable in the current circumstances. With disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, section 31, which is another section that was relied upon by my learned friend, refers to disposal of articles where no criminal proceedings are instituted or where the article is not required for criminal proceedings. Requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings, so it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles after Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that will be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your leadership to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It is not up to the state. Why that is important is also Section 35, which is another section that was not relied on. That deals with a forfeiture. So your ladyship will know under Section 34 you may order the item to be returned, but under Section 35 you may order the item forfeited to the state as well, because under Section 35 subsection 1 it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed, or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this Act, forfeited to the state. So what happened here is that the prosecutors on their own showing agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you may come and collect the firearm. Whereas the provision, Section 34, says the judge or the magistrate, whoever is presiding, may make that order. But it raises profound questions, my lady, with the greatest of respect. The first is, how does he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment about the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced, and that is in the context where a witness has given evidence. It is correct, as my learned friend points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they have this email chain, you would expect that on the day the witness gives evidence, they'll put it to her, but they don't. And then they try to get that evidence introduced in argument, which your ladyship can just dismiss without more. So we submit, therefore, your ladyship, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there, we take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the impropriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, your ladyship will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense. He's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they have imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of offenses usually show an element of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship, you'll see from our heads of argument. But the second conviction is about one bullet. It's one bullet, not the 22 bullets, one bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about one bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the court said the findings were. And the important one is 1.2. Unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. 8.223 Remington bullet. One bullet. Without holding a license, permit, dealer's license, manufacturer's license, gunsmith license, import or export, or in transit license or other authorization. 1.3 unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm, not the firearms, a firearm, one firearm. One bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. And then you can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. It's like a game that they're playing. as a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, when your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what we have is that we've got a state that chops and changes its case depending on what it wants to achieve at a particular point in time. Today, they're trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentary. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my lady, is the fourth part of it, is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as they are concerned, it's custodial. So what we say, my lady, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your ladyship cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.
Sorry. No, Advocate that is not a reason for mitigation. We are dealing with mitigation, and I am indulging the defense.
It's 18B of the heads of argument. Look at 18B. Of
on which ones? Supplementary or the first? 18B.
So there they say, Mr. Malema complains of a political vendetta by AfriForum. That's the point I'm addressing. The leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nkukatobi, I'm just quickly reading what you are referring me to. Before saying that I don't want you to say it, let me just read the paragraph.
Thank you, Madam.
Okay. Advocate Nkukatobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
Lady, it is the state that says that Mr. Malema lacks remorse because he has blamed AfriForum. I'm simply explaining.
And the Holy Spirit included.
Yes, I'm not dealing with the Holy Spirit, I'm dealing with AfriForum.
Please leave. I've spoken, so I was very clear that there'll be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused, it's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all. So do you leave or what? Because I'm not going to tolerate it. So there's a whoever wants to comment, please leave.
Like
whoever is commenting now, please leave. And from now on, I will leave that in the hands of SABC. Whoever comments or speaks, ask them to leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just make one sentence on AfriForum, because I think that's what is increasing the temperature inside.
I'm listening.
My lady, Mr. Malema is entitled to regard AfriForum as a political adversary and to criticize it for an unfair prosecution because he believes that they are behind his prosecution. What you cannot do You cannot take that political statement by Mr. Malema and take it to account in sentencing.
I hear you fully.
Yes, thank you, my lady. Then they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? Makes no sense to me at all.
Okay, I'm not going to respond, but I'm listening, yes?
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against him? Why would they have an issue with that? And why would your leadership be required to put that in your judgment in sentencing? Now, the last one is the Holy Spirit. Nothing needs to be said about that. Then C is showing no insight to the danger of 20,000 people. But if you look at closely, my lady, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D, he has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the courts from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told come on the 9th to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your leadership that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so where the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making earlier, paragraph 19. Critically, the probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the Constitutional Court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone else thinks I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. And if you did that, you then violate Section 35 of the Constitution that gives him the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your leadership has been given this case, Mdantsane versus the state, by Mdantsane DJP. My lady, this case is unhelpful to you. This case is about someone with previous convictions. It is a case where minimum sentencing legislation applies. And it is a case, if you look at paragraph 2 of the judgment, where it says the appellant produced a firearm, Robbenheimer ran away and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. This is a case of gangsters. It's not a case of a politician in a temporary lapse shoots a firearm to the sky. This is a case of proper gangsters. There is absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases, and again, this is another misconception. We've cited, and I will ask your ladyship when you retire to have regard to these judgments. In paragraph 31 of our heads of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Plaskett J, S versus Matikane, where he refers to, I think at that point, all sentences that he was aware of on possession. So, my lady, you see, S versus Malema, the sentence, that it was an automatic firearm, not semi-automatic, automatic. The sentence was, there was a direct imprisonment occur. On appeal, it was altered to 2,000 hours of periodic imprisonment. S versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment. And then the last one that would be relevant for our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases, possession. And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fanyun, S versus Pistorius, Munsami, and another, and the Bada versus S, paragraph 41. Yes, 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there's no harm, no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found, discharge the firearm in the sky. I mean, the Pretoria's case was actually a paradigmic one, because it's actually in an enclosed room. It's like here in the courtroom. The place is full of people, and then Oscar shoots the fire. It's not his firearm, it's someone else shoots it to the roof. And then they say 3 years fully suspended. Don't go to prison for it. So the pattern on discharges where no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says, that there are cases you will find of 7 years. But virtually every case we've looked at that they have cited always involves, like this one we've looked at, gangsters or some sort of other offense that is, the possession is part and parcel thereof. Not one case involves an instance, which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it, excite the crowd, bring it back to me. Never found a case like that. So it is not correct for my learned friend to ultimately come to the conclusion that the pattern of sentencing and possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you have, you really have a wide canvas. A wide canvas that starts from wholly suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. My learned friend can complain about Ms. Thompson's bias, etc., but the fact of the matter is there's only one witness on sentencing, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discretion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you, my lady.
Thank you, Advocate Nkokatobi. Thank you. There's no provision for you to reply, Advocate Sisa. This is it. The defense, am I going to indulge him? It's not procedure. He wants to rise, so you may outvote him.
Your Worship, there's no reason to this. That's supplementary heads and today was for the arguments. And even after his arguments, he had an extra point to make. There's no need to, which is fine.
Okay. The extra point I disregard, but with the rest, we stick to procedure. Is it a new point?
I have no idea. So there's no need to address anything.
What you want is not raise the point, but what is the basis of you wanting to do so that I can listen to and then I can tell you yes or no.
So I was just going to advise counsel to read section 30 and up to 34.
No, that is a no. All right. Thank you, Advocate Sisa. All right. So that is us for the day.
Since no one is speaking to your leadership when you're asking, that is it for today. The one thing we agree with the state on is that we need to get finished with the case.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate that.
Advocate Nkokatobi, let me be very clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is still to be decided. Let me explain so that everyone, and I'm sure I do not have to explain, you are all senior officials and very much aware of what I'm about to say. What you read on paper materializes when it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and
I have absolutely no problem. Your leadership is adjourning us to a date to be advised.
No, we've got 2 days and I intend to do our utmost to reach our end goal. I just don't want to say and commit after I've explained why, and you all know, when you read and when someone says it's a totally different impact when you hear and when you read in your office. Then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. We can, sorry, I see you are keeping you on your feet, but you are free to take a seat. I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that. Or we can say 9 a.m., but I'm not going to go beyond that. So,
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can, Advocate Sisa, your client. I'm thinking of all the media stations and such to return for me to read out a formality which is known to all, or come back at 9 a.m. But I intend, as I say, not to go beyond and for us to reach our goal as planned.
9 a.m. tomorrow.
Then your word is my command.
I agree.
Agree, Advocate Cesar?
I agree.
All defense?
Yes, Your Worship.
All right. Mr. Malema? Just a minute, please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it is the same venue, but I'm also directed by the management. I assume it's the same, 8:30, for us to start at 9 a.m. I'm sure the same venue, which is High Court venue. Okay. Thank you. Court will adjourn.
the sentiments or even give us a summation of what those who have been gathered outside have been stating. Sakina, a very good afternoon to you. What are some of those gathered there behind you saying about at least this part of the proceedings that have just wrapped up?
Well, welcome back, Mfundo. As you can see, we're going live just as, of course, the main stage also decides to come alive. But of course, this is, of course, the part, seeing that the proceedings inside have adjourned. What we are going to see now is that the leadership will come out and they will address those gathered here today. But of course, Sam and I have been listening to the proceedings as well, Mfundo. And Sam, just to look at the touch points from what we heard in arguments in mitigation and of course aggravation of sentencing. So pretty much the points that we spoke to earlier today. Firstly, with regard to what Julius Malema has been convicted of, particularly Mfundo also touches on that point of the possession of the firearm and the possession of the ammunition. The fact that Adrian Snyman basically was given back his weapon even before the whole proceeding, the conviction was concluded. And we heard earlier from his spokesperson, that's Adrian Snyman's spokesperson, that he will be suing the state for malicious prosecution. So let's start there.
Indeed, Adrian Snyman is suing the prosecution for the state for malicious prosecution to a tune of about 21 million rands, which he says that the state should have not done this. It was malicious. They shouldn't have gone on about the manner that they went about it, which fits directly to Julius Malema's case now, which was advocated for by advocate Tembeka Ngubane, saying that the gun was returned to the witness, to Adrian Snyman, the accused, even before this case was wrapped up, and that should have been in the ambit of the magistrate to do so and not that of the state. And that just also says that they are saying there are a lot of discrepancies within this particular case that the state is pursuing against Julius Malema. Is actually saying that there has been a different treatment for Adrian Snyman and different treatment for Julius Malema on a case that is exactly the same. And also the issue of the conclusion of not there being enough conclusive evidence that Adrian Snyman handed over the gun to Julius Malema. And that for me is another sticky issue within this case, which will be properly ventilated should Julius Malema get that punitive measure of 15 years, because you heard the state saying they are looking between 7 to 15 years direct imprisonment for Julius Malema, leaving that room for the judge to play with between 7 and 15 years.
Yeah. And of course, punctuating that on the fact that Julius Malema is a leader of society, and not just a leader of society, he's a lawmaker of the South African society. And we heard Advocate Sisa making that point very strongly.
Indeed, they are essentially trying to make an example of him. They are throwing the law book at him, saying, you're a lawmaker, here's the book, read the book and what it says, there's no special treatment for you. So we are going for the harshest punitive measure, because ultimately you are a member of the National Assembly, you are a lawmaker, you do sit in serious committees within the legal framework of the country, the legislative framework of the country, that being the Judicial Services Commission, that employs the judges that overlook the ruling of the law of the country, essentially, and hence they are going for that harshest punitive measure to make an example of him, of other political leaders who may have the same behavioral patterns of using a gun willy-nilly in the presence of civilians.
But of course, we heard Advocate Toby in mitigation argue that all the cases that were also presented in terms of case law before the court to make the state's argument, he spoke about how all of those did not necessarily result in a custodial sentence. And that, I suppose, is the nub of the matter. It is the custodial sentence that the state is asking for.
It's going to be rather interesting, because when you had African Toby using those case laws of case studies that didn't rest in those custodial convictions at the end, how the judge goes about this particular issue, because if a precedent has been set before, and it may not be a precedent that is permissible, they may want to use Julius Malema as an example this time around to correct those case laws of the past. So it is a conundrum that the magistrate is caught with in dealing, because he has already found Julius Malema guilty. The issue is now the sentence that he gets. And also going further, he's not an ordinary individual. Unlike those other cases they may have used in case law. He's a different type of case that you treat differently because he's a political leader, and hence it will fuel the case that this is a political persecution against him on the virtue of his standing in society.
We even heard Ngugai Toby invoking the sentiment that the prosecutor was biased in this regard, taking things personally. So it's very clear they're not going to stop at anything to get their man free. But you said something earlier on in terms of how perhaps Julius Malema and his legal team did not take seriously or as seriously this case at the onset. And now we see they've brought in senior counsel in the forms of advocates Holders and advocate Ngugai Toby. And this perhaps something they should have done from the onset.
They should have brought in advocate Ngugai Toby from the onset. As I've said, Julius Malema took this case lightly. It's like, oh, it's a firearm case. It will disappear. It's at a magistrate's court. It's not that important matter. I will defend it. But without realizing that this case will be an Achilles heel towards his political career, and it may ultimately be the one that affects his political career the most, as opposed to the other ones he's faced in yesteryear. Like your on-point engineers, with Nisiba Gwangwa on that particular corruption case in Limpopo. That was he was able to win. But this one is a different type of case where there is actually evidence of him branding that particular gun, shooting it in the air. Siko works MP of the EFF was just reminding us of how this particular case came about from the Sisa Dukashe Stadium in 2018 and where we are today, and how it was taken lightly that it will be, by the way, it will go away at some particular point in time until the conviction of being guilty.
Indeed. And of course, what we see now, Mfundo, is the EFF leadership that was in court making their way to the stage. And this is, of course, where Julius Malema is expected to address the crowds that are gathered here. So becoming pretty impossible to hear anything right now. So we also in the way of those trying to make their way to the stage to listen to the man they all came to support. So we are going to take you there to those proceedings, have a look at what's happening, and also get ready to hear what Julius Malema will be saying to those gathered here. But also not forgetting that the court has adjourned until 9 a.m. And it was quite interesting what the magistrate Toinette Olivier had to say there towards the end, where she was speaking about listening to the evidence in real life as opposed to reading the words on a piece of paper, words that lacked a tonality that she will now go and apply her mind to. So we can see that the leadership is already on the podium there, and Gabi's going to show you that, and we are going to now shift our focus as well, Mfundo, to what will be said by Julius Malema there on the stage. From our vantage point, I can see he is on the stage, but I think you have a better vantage point at this point. Mfundo, back to you.
All right, Sakina Kamwendo, the SABC News anchor, in conversation, of course, with senior politics reporter Samkele Maseko. Indeed, I do have a better vantage point. Saw those visuals just swiftly there of EFF leader Julius Malema, his Secretary General Marshal Dlamini, and I believe I would have seen his wife there, Mantwa, as you can see. A number of family members being among those who came to support EFF leader Julius Malema in a number of occasions whenever there have been either legal movements or political events, not necessarily much focus on the family that would be there in support, which of course generally there would be, but this time around quite important to have his family there, given that many are calling this a pivotal moment in his political career. He does face possibility of direct imprisonment, as you would have heard. That remains the state's request. They are looking at a sentence of either between 7 or 15 years. They believe custodial time would send a strong message to society, according to them, that such conduct, which is the discharging of a firearm in public, is not something that should be accepted in civilized South Africa. We would have heard the rebuttals from the EFF leader's legal representative, Advocate Ngugai Toby, who went on to state and almost squash many of those statements, particularly around remorse, saying that when the EFF leader was before the courts or outside the court and went on to state that he believes AfriForum is behind this, or went on to speak of the incompetence of the NPA, it should not be considered to be something that speaks to his level of remorse for the conduct of the day at the Sisa Dukashe Stadium. I just want to draw your attention now to what you're seeing on your screen. This is our poll that we're running for this all-important story. We're asking you, what do you think will be the sentence handed down to Julius Malema? Of course, court today, has wrapped up, commences tomorrow in the morning. 65% of you have said it would be a suspended sentence. 9% of you saying less than 12 months in jail. 12% 3 to 5 years jail time, and 14% saying maximum sentence. So of all of you that have participated, a majority believe what we're going to hear here at the end of this case is a suspended sentence. Well, we continue this conversation. We're now joined by political analyst Asanda Mwasheng, just to get a sense of what this moment really means. A very good afternoon to you, Asanda. A number of commentators are calling this a very pivotal moment.
The CCT members and other provincial leaders, we greet everyone, and we see the Red Sea of the EFF is here with us. The ground forces, Pagama, ground forces, Pagama. Saitati Eastern Cape, Saitata. Down with Oscar Mabuyana, down. Down with Princess Faku, down. Thank you very much, leadership. We are greeting you. President, we are standing with you. These are your people. This is the only, thank you very much, leadership. We are greeting you. President, we are standing with you. These are your people. This is Eastern Cape alone. We said we are going to leave everything. We are going to be with you. We started yesterday. The pastors were with us. Batanda, Commander-in-Chief, I'm a fighter, ehlele hlobo, bahlala ubusubonga, abanye basukela u-6 abanye basuka eBizana, abanye basuka eMatatiela, abanye basuka eKogama, le. But we said we are going to defend our leader and we are going to defend our organization. The 2024 NPA took a decision that we must rebuild this organization, even here in the Eastern Cape. And we must defend this organization. And we must advance the struggle for economic freedom in our lifetime. We are here, President. We are standing with you. We are happy to see even Umama. You are the father of the revolution. But we know behind every successful man, there is Umama. I wonder just to greet and hand over to Imbogoto, our national chair, to take over the session. Thank you very much.
Amandla! Amandla! Viva EFF, viva! Viva EFF, viva! Forward with victory, forward! Forward with victory, forward! Hands off CIC, hands off! Hands off CIC, hands off! Down with AfriForum, down! Down with AfriForum, down!
Phakama Eastern Cape, Phakama! Phakama Eastern Cape, Phakama! Thank you very much, Chairperson of the Eastern Cape. Now let me take this opportunity and greet the Commander-in-Chief, Yaka CIC, ndithi kuni sinani kule ndlela nihambayo. Greet apho ndibulise the leadership of the EFF, the top 6. Ndibulise the provincial leaders that are here, the Central Command Team, and most importantly, the ground forces. Ndithi alala ground forces, alala! Alala ground forces, alala! Thank you very much, fighters. Asizukubabade, sizawunikela umongameli, u-SG uzawuza ngaphambili u-DP. Where's DP? U-DP uzawuza azonibulisa before sinikela umongameli. Thank you, over to you, DP.
Phakama Eastern Cape, Phakama! Phakama Eastern Cape, Phakama! Phansi nge-AfriForum, phansi! Phansi nge-AfriForum, phansi! Phakama CIC, Phakama! Amandla! Woza local government election 2026, woza! Comrade President, abantu bakithi bafikile basephondweni laseMpumalanga. Iphondo le Kapa elila e-Eastern Cape. Comrade President, now our supporters, number ground forces. We welcome them, we welcome the family, we welcome the leadership. We are here to put up a statement
time on the stand to
the magistrate and to the state that never again shall they persecute our president. We are here to defend our president. Comrade President, our people are waiting to hear from you. Comrade President. Manza! 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 Forward to EFF, forward! Tata, EFF, Tata! Tata, EFF, Tata! Auma Guluiwe! Auma Guluiwe! Auma Guluiwe! Manza! Niyabasabana! Niyabasabana! Down with AfriForum, down! Down with this term, down! Down with African Dome, down! Manza! Thank you very much, DP, our National Chair, Secretary General, DSG and the TG, the provincial leadership and all sub-regional leaders who are here, and the ground forces of the economic emancipation movement, and all family members who are here to come and support us. We appreciate your support, and you must be rest assured that we do not take your support for granted. When we grew up, persecution has always been part of our life, because capital want to use us to silence the dejected masses of our people. And we know what is at play, and we are not in any doubt that capital has got a central role in trying to silence the radical voice in South Africa. And they use us to say, whoever dares to speak truth to power must be taken to jail. We shall not be silenced under any circumstances. They can do whatever they can do, they will never silence us. They can imprison me, but they will never imprison my ideas. They will never suppress the idea of economic freedom in our lifetime. So fighters, we have come to the conclusion of the case. and the magistrate has asked that we give a chance and time. She will deliver judgment possibly tomorrow, 9 o'clock. So we are not going anywhere. We are going to wait here until she delivers her judgment. But I can rest assure all of you, and I was telling some young journalists I was talking to inside there, that tomorrow when they go home, these journalists, I will be going home with them. They are not leaving me in this High Court. So we are saying, let's be disciplined and listen to our leadership. We will not go into the details of the case because we have canvassed our ideas inside. Now it is for magistrate to take a decision. Like we said, it doesn't matter the outcome. The fact that there is a guilty verdict, we are going to appeal this case until the highest court in the land. And when you say you are appealing a case, it doesn't mean you don't show remorse. It means you disagree with the conclusion of the magistrate and therefore you appeal. It is allowed by the Constitution of the Republic of South Africa. So when you exercise your rights, which we fought for, which we are still fighting for, it doesn't mean you don't show remorse. It means you disagree, and the laws of this country allow you to disagree with magistrate, to disagree with judges until the Constitutional Court makes a final decision. Only then you will accept that I was wrong because the Constitutional Court said so. Otherwise, the laws are there to be used to protect us and to make sure that we too exercise our rights and no one takes away those rights. We have been here for many very good to us since we started this trial. You have been coming in your numbers to support us, and we appreciate all of you, especially the ground forces here in East London. We know you are going to take this municipality come the next elections. Comrades, it's not only you who have occupied the streets of the courts. In the whole of South Africa, the fighters are at each and every high court protesting against this persecution which was brought to us by AfriForum. We must never forget the fact that we are here because of the AfriForum, which wants to silence the voice of black people. We've got our fighters in Western Cape, we've got our fighters in KZN, in Mpumalanga, in Gauteng, in Free State, in Northwest, in Limpopo. They are all, as we speak, on the streets fighting against an injustice. They too arrived last night and they too will leave tomorrow when a judgment is passed. We salute all of them wherever they are. We say to them, thank you very much for the support. We want to thank everyone who has been praying. We received a lot of letters, we received a lot of messages, people telling us that they are praying for us. Some churches have gathered in prayer so that everything goes according to the will of God. So we don't take those prayers for granted. And old people are here. Many of them are panicking. They don't know what the future holds. They've got no reason to panic. The future is economic freedom. With or without Julius Malema, it shall be attained in our lifetime. We want to reassure all of them that there is nothing that will disrupt the revolution. I stand before you unshaken by the threats of white supremacists. And because I fought them when I was still young, I'm too old to be shaken by young Afrikaner boys that have defeated their parents. So no one has no reason, none whatsoever, to panic. We don't take advantage of their support. Here with the president of the Lambas is also here. The pastors are here. Traditional healers are here. Traditional leaders are here. My wife is here. My child is also here. So my aunts are here because they all took a decision to support me. All of them are one family. We are all one family. My father, Mr. Maja, and my mom, the wife is here because we are all one big family. And that family is called the EFF, not Malema family. We are the EFF family because no one is above the EFF. The EFF made us who we are and will forever respect it and support it. So fighters, let's continue the discipline. The SG is going to speak to you about how we are going to go forward. And through those directives, you should know that we are here in East London. So if you misbehave, you are going to confront some of us because we will not allow anyone to tarnish a good image of the EFF. We must all protect the image of the EFF. There will be agent provocateurs amongst us. When they do wrong things, those who love the EFF must be the first ones to call them to order and say, if there is a time to attack, the leadership will give a command that we must attack. We don't lead ourselves. We've got leaders who are leading us, and we have to listen to those leaders. Comrades, thank you very much. I know a lot of our friends are here. They used their own money to come here. No one invited them here. They woke up and said, we are going to stand side by side with the EFF, and that kind of friendship must be cherished and be celebrated. Many of them are business people in their own right. They will be in 1 or 2 meetings, but they've cancelled all of those meetings to be with us here, and we really appreciate their support, and we don't take their support for granted. Comrades, you must be strong, because if you are strong, our people will be strong. Not for a second show a face of doubt, because if you show a face of doubt, you make the enemy happy. So even when we have no reason to smile, when someone looks like an enemy, just smile, because they are hurt by the fact that you are smiling. The fact that they see us all here together, they are hurt. The pain goes straight into their heart. When they listen to Senior Counsel Lawrence Rhodes, a Jewish man, arguing positively for us, the pain goes to their heart. When they see Tembeka Mugaitobi demolishing the short prosecutor, the pain goes straight to the heart. We thank our legal team. They've never misrepresented us. We are confronted with injustice. It doesn't matter how good your lawyer can be. When there is a predetermined outcome, they will always rule against you. Even Bamushate, I see you, Bamulechi, Hoshikabu, Wabraru. They are here to support us. Please send our message that we really appreciate the support and your presence. Amandla! Amandla! FIFA! EFF! FIFA! Tata! EFF! Tata! Tata! EFF! Tata! Down with AfriForum! Down! Down with AfriForum! Down! Down with Malan! Down! Down with Fairwood! Down! Down with Porter! Down! Amandla! Thank you very much, SG.
Amanda! Amanda! Viva EFF! Viva! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live. 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 Man down. Thank you very much, President. Greetings to the family, to all the leadership, the ground forces. Vele sivumelele President ukuthi bayathanda bathandi sizagoduka nawe. It doesn't matter ukuthi bathini, siyajabula ukuthi nawe uyiconfirm ukuthi xa usuka apha ubuyela ewini Madikizela House ngoba unomsebenzi wokuleader i-EFF with elections. Fighters, into ezakwenzeka ngoku njengasenzile niyayazi indawo yethu phaa stadium. Esa stadium sesethu, i-East London yonke yethu, i-BCM yonke yethu, i-Eastern Cape yonke yethu. So into ezakwenzeka ngoku sizawukhulula upresident nenkokheli nomndeni ukuthi bahambe, nabameli bethu ukuthi bahambe bawuqhubeka nomsebenzi. Thina silapha nani. Into ezakwenzeka ukuthi sizawuvula apha sibese sihambe ngendlela esifike ngayo ekseni sibuyele phaa stadium apho sizafike silungise zonke izinto zethu thina as fighters ngoba asiyindawo. Even if tomorrow they don't finish, Friday we are here, Saturday we are here, Sunday we are here, we'll be here every day until sithatha upresident wethu sibuyele naye ekhaya. Amandla, amandla. So into enzoyenza nzoma nje kanje, Tina will come and lead you from the front, and then we'll walk all of us going back to our area. Lapho sizaqala khona our own program ngoba akulalwa. Sifuna ukuthi mongameli hambe uyophumula ngoku nefamily. Thina sawuhlangana nawe ngomso apha ecourt lebhulukazi AfriForum, all of them abeze sibalingene. Amandla. Thank you very much. Play music there, TJ.